Well, good morning, everyone. Thanks for being here. Many of you in person, some of you remotely on Zoom. We're very happy to have you here for the ACUS Forum on International Regulatory Cooperation. My name is Andy Fois. I had the pleasure of meeting most of you earlier. I am the chair of the Administrative Conference of the United States, which often goes by the name ACUS. For those of you perhaps not as familiar with ACUS as others, ACUS is an independent federal agency that has as its mission to, as I like to say, just make the government work better. When I tell that story to people who aren't lawyers or experts, they say to me, "Well, you've got a pretty big job, you know." And the other day, I was telling my doctor about it, and he said, "Did you say you're a small agency?" I said, "Yeah." He said, "It should be a lot bigger." And of course, we try to make the government work better by focusing on gathering information, doing research, and making formal recommendations from the Assembly for administrative agencies to help improve administrative procedure and administrative law and agency processes. The conference itself consists of a 101-member body that we call the Assembly. It's split pretty evenly between 50 representatives from various federal agencies, and then the other half dozens of scholars and academics and experts and practitioners. And then it's the Assembly that makes the formal recommendations to the rest of the government, be it the agencies, be it Congress, or the judiciary. Today's forum actually makes a return by ACUS to the subject of international regulatory cooperation, but we've not considered it in some time. So I'm going to focus my hopefully just a few minutes on the work that ACUS has done in the past. First, I'd like to thank some people, starting with, of course, the triumvirate of Kathleen Clausen from Georgetown Law. Where are you, Kath? There you are. She has been urging ACUS to take up the subject for quite some time. So we're very grateful for her to that and her participation. Her colleagues, Professor David Zaring. David, there you are, right in front of me, from Wharton, and Elena Chachko from Berkeley. Thank you for your support and your partnership. In addition to organizing and moderating today's panels, David, Kathleen, and Elena are preparing a report for ACUS on developments in international regulatory cooperation over the past decade or so. And thank you to all of the many experts who are participating in the panels today. Again, some live, some remote, and thanks to all of you once again for attending. Some special thanks for ACUS staff huddling over there in the corner. In the middle is Kaja Novatsky, who has really done the bulk of the work on researching the subject and working with the triumvirate of the three and setting up this forum today. To her left is Amina Gore, program assistant, who also did a lot of the work for today. And to Kaja's right is Jeremy Graybois, our research director, who many of you may know. So let me sketch out the history of ACUS involvement in this, and Jim, jump right in when I'm leaving something out. Jim Tosey is our senior ACUS member and the former first director of OIRA. We're very honored to have his distinguished presence with us. So in the early 1990s, ACUS commissioned Professor George Berman to study and report on cooperation between the Federal Aviation Administration and similar regulatory agencies abroad. The report begins with this observation, quote, "The character and pace of world developments suggests that if American administrative agencies ever could afford to engage in regulatory policy without regard to the policies and practices of administrative agencies abroad, that era has come to a close." And that strikes us as a remarkable statement, especially for its time. So informed by that study, the conference adopted a recommendation in 1991, encouraging agencies to familiarize themselves with the activities of relevant regulatory bodies outside the country, communicate effectively with those counterparts abroad, and determine appropriate modes for cooperating with non-US entities in pursuit of their statutory missions. Less than a year later, in February 1992, EU member states signed the Maastricht Treaty, which I know you all know, paving the way toward a more integrated Europe. 2 years after that, in April 1994, 123 countries signed the Marrakesh Agreement, establishing the World Trade Organization. And over the next 20 years, the volume of trade and goods and services and information across borders continued to increase. So because of those developments, in 2011, ACUS embarked on a project to assess how the 1991 recommendation had been implemented, identify new challenges that had emerged over the previous 2 decades, and advise how the 1991 recommendation might be updated to guide agencies in improving international coordination and to benefit regulatory goals and competitiveness. Finding new challenges and opportunities as ACUS sought to do that, the conference adopted another recommendation that year that emphasized or re-emphasized parts of its earlier statement and identified new best practices for transparency, information sharing, and coordination within the United States. Less than 5 months after that, in May 2012, President Obama issued Executive Order 13609, promoting international regulatory cooperation. And we'll hear more about this order in the first panel, so I won't go into too much of it. You probably know a lot of it already, but the order did endorse much of the conference's 2011 recommendation, and we're always happy to have that sort of effect. The order also directed the Regulatory Working Group, which is chaired by the inquire administrator, to foster communication and coordination among federal agencies and examine appropriate strategies and best practices for international regulatory cooperation. That was a dozen years ago. And here we are now in 2024. The world, of course, has continued to change, and administrative agencies have been changing with it. As we survey the field, we continue to confront old challenges and many new ones that may benefit from cross-border information exchange, regulatory cooperation, and policy coordination. And so just as in 2011, when ACUS took up the task of examining developments since 1991, today we again look at agencies' experience over the past dozen years to identify remaining barriers to and potential best practices for the future of international regulatory cooperation. So that all said, we have a great program for you today. First up, Professor Zering will moderate a discussion examining what international regulatory cooperation was like prior to the Executive Order 13609, the origins of that order, and how agencies implemented the new framework. Next, Professor Clausen will lead a discussion focused on the growth of cross-border cooperative efforts, international organizations' undertakings to complement and amplify national programs, and the evolution of those undertakings over the past decade. Our lunch speaker is the Honorable Judge Timothy Reif of the Court of International Trade, who will offer what we're calling a fireside chat. So I hope you all have your radios to listen to that. And then finally, after lunch, Professor Chachko will speak with experts about the executive order, what it's accomplished so far, and the potential best practices for the future. So let me introduce first our first moderator, David Zering, who will then, like all the next 2 moderators to come, will introduce the rest of their panelists themselves. David is the Elizabeth F. Putzel Professor in the Legal Studies and Business Ethics Department at the Wharton School. And did I pronounce Putzel right?
Yeah.
Okay. David writes at the intersection of financial regulation, international law, and domestic administration. He has written over 50 articles, including publications in Chicago, Cornell, Michigan, NYU, and Virginia Law Reviews, and a number of international law journals as well. He is co-author of The Globalized Governance of Finance. In addition to teaching at Wharton, he has previously taught at Cambridge, Penn, Vanderbilt, and Washington and Lee law schools. He's testified many times on financial regulation before Congress, writes an occasional column on the subject for the New York Times Deal Book. Professor Zering.
Thank you, Andrew, for that kind introduction. What we're hoping to do on this panel is first I thought I'd talk a little bit about Executive Order 13609 and what it sort of embodies for regulatory cooperation. And then I wanted to ask our first panelist, one of our panelists, Alex Hunt, about how that order sits in the context of international regulatory cooperation more generally. And Alex is the perfect person to ask about that because he's the branch chief for information policy at OIRA and has had an important role in sort of implementing and overseeing how OIRA engages with this requirement that that international regulatory cooperation be considered. Then I'm very much looking forward to getting some perspectives, sort of comparing international regulatory cooperation from the United States to alternatives in Europe and the rest of the world. So we've got two excellent people to serve that role. Francesca Bignami is the Leroy Sorensen Merrifield Research Professor of Law at George Washington University School of Law. And Jonathan Weiner is the William R. Perkins Professor of Law at Duke Law School, a professor at Duke's Sanford School of Public Policy, and he's also appointed at the Nicholas School of the Environment. I'll tell you a little bit more about their bios when I call on them, but first I thought I'd talk a little bit about Executive Order 13609 more generally. Many of you will know something about it, but I also wanted to sort of put some of our conversation in context. Okay, so the executive order endorses international regulatory cooperation at the White House level. It is indeed an executive order, but it was not created in isolation. And one of the things we've seen as we've engaged in this project is that international regulatory cooperation existed before Executive Order 13609, and Andrew Fois talked a little bit about how ACUS has been a part of encouraging people to do that kind of thing. And it's proceeded after the promulgation of the executive order, both under the auspices of the order and then independently without sort of OIRA oversight, if I can put it that way. So the executive order, Cass Sunstein, who was the head of OIRA when the order was promulgated, said that it had a simple goal to promote exports, growth, and job creation by eliminating unnecessary regulatory differences across nations. Okay, so that's the pro case for what we can get out of international regulatory cooperation. And of course, there are some people who think of that sort of cooperation as controversial. Public Citizen, once the order was promulgated, described it as a smokescreen for deregulation. So that's the perspective of some outside groups. The order itself said, as a matter of policy, that and I'm quoting from the order here, in meeting shared challenges, US agencies and their foreign counterparts could, through international regulatory cooperation, identify approaches that are at least as protective of those that are or would be adopted in the absence of such cooperation. International regulatory cooperation, the order says, can also reduce, eliminate, or prevent unnecessary differences in regulatory requirements. Okay, so that's the statement of policy. Then, as Andrew has said, the order tasked the regulatory working group chaired by the administrator of OIRA with supporting international regulatory cooperative efforts. And it imposed two requirements on executive branch federal agencies. Agencies that were required to submit a regulatory plan were charged with including in that plan a summary of international regulatory cooperation activities anticipated to lead to significant regulation, so a reporting requirement. And a second reporting requirement is that the agencies were charged with identifying activities with significant international impact and tagging those in the unified agenda of the federal regulatory and deregulatory actions. Okay, so when this order was promulgated, I wrote about it, as did a number of the people who you'll be hearing from today. My ivory tower perspective was this is an endorsement of regulatory cooperation. It's something of an endorsement of American style administrative procedure. And I think we'll hear more about that from and also it was an interesting shift in trade policy, centering regulatory cooperation, or it represented something that would be pursued by the United States in trade deals with its foreign counterparts. And I think one of the things you'll hear over the course of the day is that there's a trade-related sort of push behind regulatory cooperation. The goal is not just to harmonize things, but to harmonize things in a way that makes sort of, free exchange across borders more possible. Okay, so enough about the ivory tower. Let's hear about the executive order from maybe one of the people who knows it best, and that is Alex Huntz. And Alex, I thought maybe you could cite the discussion by talking a little bit about how regulatory cooperation was pursued before the executive order, and some context for the executive order itself.
Thanks, David, and thank you to ACUS for inviting me and bringing me here and reconnect with some old friends and colleagues to talk about something that I have spent a lot of my career working on. And that career started when I joined OIRA towards the end of the 20th century. And at that time, OIRA was very much viewed, and I perceived it as a domestic policy agency. There was not much talk about international activity, and that changed over the years, and we became increasingly engaged internationally in a number of areas. Within international organizations, we had a couple of regulatory dialogues with the European Union. We met frequently bilaterally with foreign government delegations who wanted to learn from OIRA about the US approach to regulation. And just prior to the issuance of EO 13609, we launched 2 regulatory cooperation councils. So the international organizations are APEC and OECD. In APEC, initially our work supported the development of something called the APEC OECD integrated checklist on regulatory reform. It was issued in 2005 and was one of the, I would say, first most meaningful statements reflecting an international consensus around good regulatory practices. Then in OECD, OIRA has a history where one of our policy analysts went to Paris and helped OECD stand up its regulatory policy program in the mid-90s. And OIRA has been the US delegate to the committee now called the Regulatory Policy Committee. And so we're very active and engaged in OECD. I would mention that in 2012, the OECD issued its recommendation of the Council on Regulatory Policy and Governance, which at the time, and I would say even now, is essentially a gold standard for meaningful good regulatory practices that, again, has a strong international consensus. And I would say this phase of our work, OIRA was drawn into it because of a broader US government policy of promoting good regulatory practices abroad, on the theory that to the extent other governments adopted open, participatory, evidence-based, full of government approaches to regulation, that would foster US exports into those markets. And OIRA, as the regulatory oversight body in the US, could speak to those issues and help advance that broader US goal. Is that a ding? All right.
Not for me.
You can just tell me to shut up if I have to go too long. I'll mention the two EU initiatives. OIRA co-chaired a US-EU high-level regulatory cooperation forum that was established in 2005. And it was a dialogue, so exchanging best practices about regulatory impact analysis, public consultation. It met 9 times through 2011. In 2007, the Transatlantic Economic Council was established at the cabinet level, and the TEC explored opportunities for regulatory cooperation with the goal of reducing non-tariff barriers and to promote SME exports. And I'll mention a few of the sectoral priorities under the TEC. There was a project on nutritional labeling led on the US side by FDA, energy efficiency of certain electrical products led by DOE, Energy Star led by EPA, Suppliers Declaration of Conformity, SDOC was an OSHA-led project. I'll mention just some of the governments we met with around this time: Brazil, Italy, Poland, Sweden, China, Vietnam, Morocco, Korea, Kazakhstan. They all came wanting to know how the US did regulatory policy. And then, as we'll talk a little bit more about later, in May 2010, the US launched the High-Level Regulatory Cooperation Council with Mexico, and in February 11th, the US-Canada Regulatory Cooperation Council.
So that's a lot of regulatory cooperation that's sort of getting going before and, I guess in some cases after the executive order. So what was the purpose of promulgating the order? What was it supposed to do that was additive to these sort of regional and multilateral efforts that were already ongoing?
So I think in 2012, there was just a growing recognition, and the ACUS recommendation was part of that, contributed to that, that awareness that the regulatory playing field was global, supply chains crossed and recrossed borders. A lot of the customers of US firms lived in other jurisdictions. And at the time, the international trading system was viewed, look forward to your thoughts. It's at the time of having succeeded at knocking down most of the at the border barriers to trade and investment. So for governments looking to improve economic performance at home, the next step was to look at the behind the barriers to trade, and that's where you get into regulation. Specifically, the regulations that differ for no good public policy reason, but create real costs for producers and consumers. So that was the basic rationale for EO 13609. The policy was that IRC can identify and address existing regulatory misalignments and prevent future ones, that US regulators can be more successful in achieving their domestic regulatory objectives if foreign regulators adopt similar approaches. And there was a continuing need to promote good regulatory practices, such as what I described prior to 2012. So the goals were promote US efforts to eliminate these unnecessary regulatory differences, to improve regulatory outcomes, and pursue joint regulatory approaches that are at least as protective as those that would be chosen in the absence of regulatory cooperation. And as mentioned already, tasked the regulatory working group, which is an interagency group chaired by the OIRA administrator, established in Executive Order 12866 in 1993, that has long coordinated regulatory work. So in tasking the Reg Working Group with implementing 13609, it sort of embedded it further into the structure here.
maybe that's the answer to the question I was next going to ask, but why OIRA? There's been plenty of regulatory cooperation efforts that have come out of the various departments and the agencies as you've described, but OIRA has a sort of important central role in the executive order and in the president's work, the regulatory working group. Why center regulatory cooperation in OIRA itself?
Because we're the regulatory oversight body that in our day jobs are reviewing and overseeing the regulatory work done in the US government. And that's a relationship that goes back, at least to the Reagan administration, where we're reviewing draft regulations, issuing guidance to agencies on regulatory impact analysis, and producing the semi-annual unified agenda of regulatory actions, the annual regulatory plan. So in this oversight role, we have the ability to engage with regulators. And a lot of what we do in OIRA is on behalf of the president, ensure that what regulators are doing reflects the president's policies and priorities, which of course vary from president to president. And I guess I'll make the related point in the context of IRC that, there's a lot of talk about OIRA's role, the role of the trade authorities like USTR, Commerce, and State play a role, but really the regulators are the key actors. They have the authority, the expertise, the resources to engage with their counterparts in other jurisdictions to move the needle on these goals of addressing, preventing, eliminating unnecessary differences. So to get them engaged, you need to have the central oversight body engaged.
I'll try to be mildly provocative here. So how is international regulatory cooperation going? And here comes the provocative part. We've had a current presidential administration and the prior presidential administration seem to be sort of more interested in maybe cooperating less and certainly bringing trade home as opposed to pursuing it and reducing regulatory barriers. The old WTO model of, the next mile of free trade is regulatory harmonization and consistent regulation across borders. And my sense is we're seeing a bit less of that in the emphasis of the last two presidential administrations, including the current one. Okay, so that's my long-winded way of saying, how's this international regulatory cooperation going? How's it been going since the executive order was promulgated? And are the institutions that you've identified continuing to pursue regulatory cooperation? How's the project coming?
Well, let me start with what was happening immediately after the 13609 was issued in May of 2012. The first task was to develop guidelines. The regulatory working group was tasked with developing guidelines to implement the executive order. It took us about 3 years to do that. It was a very obviously lengthy process, but the one that got into the nitty-gritty, defining the terms and giving agencies more specific instruction on how to meet their responsibilities. And in terms of regulatory cooperation, the most ambitious initiative the US has had has been with Canada in the Regulatory Cooperation Council. So in August of 2014, the RCC issued what we call the Joint Forward Plan. It was informed by our experiences and lessons learned implementing the 2011 RCC Joint Action Plan, which was very issue-focused and sector-based. The Joint Forward Plan was an attempt to build on that and have US and Canadian regulators negotiate partnership agreements to institutionalize the commitments. The RCC was reaffirmed in June of 2018. It's an MOU. In December of 2018, we held a stakeholder forum in DC. About 300 stakeholders and regulators were there. Breakout sessions focused on particular sectors like transportation, health, energy. And in September 2019, we had an official RCC meeting. And then outside of the RCC, OIRA signed MOUs with Israel in 2017 and with Brazil in 2018, setting up dialogues to discuss regulatory cooperation. And I would say that up until that point was the period of most intense regulatory cooperation, where you're actually having regulators talk to each other and engage and really focus on the goals of 13609. It's not as active as it has been. I think that's clear to anyone who's been observing this space. And like I said, I've been in OIRA a long time, and priorities change. And for OIRA, IRC has largely been a demand-driven activity. People come to us and say, we're gonna do this or co-chair this RCC. And so I don't have much beyond to say about that, since that is certainly above my pay grade. But yeah, it's a different landscape now.
Are there things about the Canadian experience that make it different from other efforts that you've seen agencies engage with? Is there something about the RCC that makes it? It sounds like there's been a lot of engagement there on both sides of the whatever 5440 or fight. I don't know the order. So I don't know. Is there something that's working there in particular that people who are interested in this could draw from?
Yeah, it is unique, and it has more to do just with the basic reality of it's our largest trading relationship. We have this long border. We have very similar approaches to regulation. So those are all factors of success. And, at times the Canadian government has been very ambitious and sought out this cooperation. And again, above my pay grade, there, at the leaders level, there are discussions and commitments to do the work. And once you have that leaders level direction, then we can get to work and actually produce regulatory outcomes that are impacted by something like the RCC.
And what about methods? I didn't plan on asking you about this third country, but let me ask you about our top 3 trading partners. So Canada, Mexico, and then maybe we can get to China and see if there's anything going on there. But what about Mexico? Our second largest trading partner, also an RCC, I take it, or at least a high level cooperation. Are there things that are working about that relationship or not working about that relationship, or ways you would characterize it as different from what's happened with Canada or similar?
Yeah, it's certainly different. And the first Regulatory Cooperation Council was with Mexico. And it started off with a fairly ambitious work plan. We continued to work on the work plans for 4 or 5 years. And gradually, the regulatory cooperation work with Mexico gravitated to the high-level economic dialogue, which was co-chaired on the U.S. side by the Vice President Biden at the time. So, yeah, it was not as ambitious, I would say, as the U.S.-Canada work plans in terms of number of initiatives or the progress made. And then I would just again say that for RCCs, the leader level engagement and direction is important. And I think, in terms of the Mexican government's desire to cooperate, we haven't seen that in recent years.
So it sounds like political attention to this project is pretty important, and that's one distinction. Okay, so I'm sort of surprising you with this question, but do we have regulatory cooperation efforts with China that you've seen as far as OIRA goes, sort of standardization processes, or is that something that's
Nothing that OIRA is involved in. And I should make the point that EO 13609 was never intended to be a tool to manage all of the regulatory cooperation that happens between the US government and other governments. We haven't even scratched the surface about what US regulators do on a day-to-day basis with their counterparts. A lot of work happens. And 13609 was seen as a way to coordinate it from between centers of government to intervene or prod, push, move things along where there were some sticking points. So while I'm not aware of what regulatory cooperation is happening between the US and China, I would guess something is happening, but OIRA is not involved.
yeah, another thing that I know about as far as regulatory cooperation goes is regulatory cooperation on bank capital requirements, which happens with agencies that are independent and not subject to OIRA, and is nonetheless extremely active setting those capital levels. And some of you may have heard of the Basel III endgame controversy about rules that the Federal Reserve is trying to come up with for banks. I've seen advertisements during football games over this rulemaking and the pushback to it. And I guess that wouldn't be something that OIRA was involved with because it's independent agencies and it's happening.
That's right.
So I wanted to ask you some sort of overall assessment questions about what works with regulatory cooperation and what doesn't, and then turn it to Francesca and then Jonathan, and then we'll spend a little time at the end of the panel to hear your questions and any insights you have on what we've talked about. You've been at this for a long time. OIRA's been at this for a long time. What would you say works and what doesn't work when it comes to regulatory cooperation?
What works is when you have a combination of political will at the leader level, alignment and regulatory practices. You have similar approaches to public consultation. You have a central oversight coordinating body in both governments. You both have robust methodologies to assess the impacts of regulation. There's a high enough volume of trade to make it worth it to engage in regulatory cooperation. That's what I think leads to success. And if any of those are missing, it's going to be challenging.
And can I infer from that sort of like an OIRA counterpart seems to help in these kinds of situations if there's somebody out there sort of coordinating regulation? I think we may hear a little more about this from Jonathan, but I don't know. What do you make of the role of a sort of overseer of regulators?
Yeah, I think it's critical. That's one of the basic GRPs that's been recognized by APEC, OECD. And when it comes to regulatory cooperation, having the single point of contact who you can go to, who on their side can bring in the relevant regulatory body to work on whatever is at issue versus not having that office that you can call and have to figure out what's happening in another government. That's not workable.
What about those You've mentioned the groups like APAC and OECD and stuff like that. Is that an important driver of regulatory cooperation? Or, you know, I mean, I'm not saying that it's something that needs to be pursued at the cost of any ends, but how would you characterize your experience with these sorts of regional bodies or multinational bodies that do this kind of work?
Yeah, I think their role is very important. I think these instruments like the checklist for regulatory reform and the OECD recommendation from 2012, they did a more recent one just on IRC. I think they're very important because governments have to sign on to these principles and practices. And you know, I hope I've explained why the relevance of GRPs to international regulatory cooperation. You can't cooperate, say, if you can't see a draft version of a regulatory text in another jurisdiction, that if you're a US firm, you want to enter that market. If you don't have a meaningful opportunity to know that regulation is being proposed and have an opportunity to provide input to that non-US regulator and say, hey, that this is going to create these costs. I don't think, I think if you make this change, you can achieve your regulatory objective and lower the cost to us. If the regulator is, you know, open to that, then a basic GRP like public consultation can facilitate international regulatory cooperation. We've talked about the role of oversight bodies. Analysis is also crucial. Our OMB Circular A4 does address and mentions the update to OMB Circular A4 that was issued late last year, mentions EO 13609, and you know, having an analysis of a rule that has international effects and spelling it out in the analysis helps all commenters inside and outside of the US to understand those implications and react with comments during a public comment period. So yes, I think what OECD is very important.
Great. Well, now I wanted to turn to Francesca Bignami, who, as I said, is a professor of law at George Washington. Before that, she was a professor of law at Duke Law School. So this is secretly a Blue Devils panel or a Blue Devils alumni panel. She's written widely on comparative administrative law, and in particular about the administrative law of the European Union. And she's the co-editor of an absolutely seminal critical work in the field titled Comparative Law and Regulation, Understanding the Global Regulatory Process. And I highlight that book because I am the other co-editor. So it's still available, your Christmas presents. Francesca, so you've been looking at regulatory cooperation between the US and the EU for a while. How has it changed? How did it happen then? And how is it happening now? How would you characterize the evolution of whatever it is that's happening between the United States and the European Union?
Well, thank you very much for the invitation to be here. Thank you for the kind introduction, although it has spillover for you.
Self-serving. Yeah.
Yes. So I wanted to first talk about you following on this question about then and now. And focus on the EU side and the EU-US relationship. Over 20 years ago now, I wrote a chapter for an edited volume by Greg Schaefer and Mark Pollack called Transatlantic Governance in the Global Economy. It came out in 2001. And the book looked at EU-US regulatory cooperation, both within multilateral institutions like the WTO, as well as on a bilateral basis. Now, at the time, the main output on the bilateral side was a series of negotiations that led to the EU-US agreement on mutual recognition of conformity assessments, came out in 1999, and it's still in force in part, I believe, and it still is designed to avoid duplicating conformity assessment procedures. So essentially to facilitate trade in goods that require pre-approval before they leave the jurisdiction of the EU and come to the US, or vice versa, before they, when they go from the US to the EU. Now, In parallel to the EU-US agreements, there were a series of dialogues, which maybe you were referring to. So these were civil society market actor dialogues. There was tab D, the Transatlantic Business Dialogue. There was the Transatlantic Consumer Dialogue, Transatlantic Environment Dialogue, and the Transatlantic Labor Dialogue. And these, my impression at the time was, were designed to stave off critiques that these kinds of regulatory cooperation initiatives were designed to deregulate. And essentially stave off Seattle protest style critiques. So I actually wrote with my co-author, Steve Chernovitz, the chapter on the consumer dialogues and the environmental dialogue. Now, 20 years later, thinking about this, the question is what's changed from the ivory tower. So I can only offer you the ivory tower perspective. But the answer, looking at it from the ivory tower, is that the politics are more complex. And so regulatory cooperation, at least between the US and the EU, is more challenging. Now, at the time of the EU-US mutual recognition on conformity assessment, at that agreement, the politics are really quite low level. I think they're politics that we are all familiar with as administrative law instructors. You know, business versus environment, consumer labor, deregulation versus regulating to avoid externalities like environmental costs and other costs. And today, the politics are different because they're not just the low-level politics, but they're also politics of a more existential variety. And that makes it more difficult for the two sides to come together and harmonize. So there are three kinds of politics that I see that are new. First off, digital services are much more important for trade than they ever were before. And the politics of digital regulation isn't just consumers versus corporations. How technology is regulated affects the quality of elections and the quality of political competition within a system. It marks a jurisdiction as a democracy or autocracy. And so simply put, you know, the stakes are higher when you're dealing with digital services than when you're dealing with medical devices, which is what the 1999 agreement was one of the sectors that was covered. So that's the first difference that I see over time. The second one is that politics are more complex today because industrial policy is back in some shape or form. And so the post-Cold War consensus on regulation as the only legitimate form of intervention in markets has frayed. You know, back after the fall of the wall, basically the consensus was that a light-touched regulatory approach to markets was the best way to generate prosperity. But today we see industrial policy emerging in pandemic-related medical goods, electric cars, data, and elsewhere. So for instance, the EU's newly enacted digital package includes a variety of provisions that are designed to encourage data sharing within the EU and a certain soft form of data localization within the EU, because data is considered to be a strategic resource that the EU doesn't want to share abroad. And so in the sectors where there is industrial policy, sort of regulatory cooperation is kind of beside the point. So it's not, because there the idea is, it's not that regulatory standards and differences in standards are preventing goods and services from moving. The problem is, what prevents the goods and services from moving is that they are perceived as strategic to the jurisdiction. So no amount of regulatory harmonization is going to facilitate trade. And so the third new element, then I'll stop there, but is the American side, if you're thinking about just the EU-US relationship, but for, you know, what's very visible from the EU perspective is that on the American side, we have all the debates on the future of the administrative state. And you know, that is really a huge difference when you compare 1999 with 2024. And the result is that, you know, today, we're faced with all the many challenges that we have, the US regulators don't have the tools that they need to confront them. They don't have the legislation, they don't have the authorities under that legislation, and they don't have courts that will back them. So for the EU, they don't have the same kind of interlocutor in this cooperative relationship that they had back in 1999. And so those are the three differences I see in how this relationship looks like, over the past 20 plus years, digital economy, industrial policy, and all the American debates on the future of the administrative state.
Can I ask you about what about notice and comment regulation? So that's American style administrative law is different from Europe. Does that hinder regulatory cooperation? I get that judicial review, as you just said, would hinder it if courts take, if you don't know what's going to happen to the rule until it's litigated, then it's maybe harder to engage and cooperate. But what about the style of promulgation of American regulations as opposed to European? Does it help or hinder, or what do you think?
Yeah, I mean, I definitely think that having notice of the proposed rule is absolutely critical, because it gives all the players, all the market and civil society actors advance notice of what's going to happen, and it creates transparency for the system. So I think that's definitely very, very important. And the EU has it now. I know that Jonathan will talk about it. So I'll postpone it until Jonathan's comments. But the EU has it through regulatory impact analysis. And so it does it a lot now. So I do think that facilitates. I mean, the difficulty is that on the US side, I do think that the authorities for doing this regulatory work aren't the same. Think about the environmental space, like climate change. So we don't have the same authorities. So we can't do the same things through regulatory work that the EU can do. So but I do think that the process very much helps with the cooperation. Yeah, absolutely.
How did the EU itself develop internal regulatory cooperation, if that makes sense? The EU believes in delegation, right? Delegation as much as possible to states and localities when that's possible or whatever. But nonetheless, the whole goal is being, free trade, free movement, free, capital controls, and those, the four freedoms of the European Union. And so harmonizing the way that countries approach that must have been quite a task. How did it happen? How does it happen?
I think that's the more pertinent question. How does it happen? Because it's an ongoing process. And so that's what's interesting about this, is like, it's not a one-off sort of agreement. It's a constantly evolving process, because the regulation changes, and so therefore the standards change, and therefore there's a need to bring them back into sort of some kind of common rubric over time, the different member states. So you asked this question about how it works in the EU. So it is true that basically all law can be seen as an opportunity for regulatory cooperation between the EU 27. And so this regulatory cooperation in EU legislation takes many forms, and there's mutual recognition of standards, but then there also is standard setting in the regulation that's passed in Brussels. So the various instruments, regulations, directives, etc. So there's both. There's mutual recognition of standards in the EU 27, plus there are new standards set out in the EU instruments. And then what happens is that regulators go home. There's no EU agency that has the power to do all the implementation, and they cooperate and they regulate. And this happens in all fields. So take just the two most recent pieces of legislation that were passed at the end of this legislature, the 2019-2024 legislature, the AI Act, as well as the asylum package, which has three new pieces of regulation dealing with asylum procedures. So that all requires implementation by the EU 27 agencies. There's no one EU agency that's responsible. And you asked, I think in your questions are there, whether there are lessons that can be learned. Yep. And I feel I love to learn lessons. I'm a comparative lawyer, but in this case, I feel like the context is just too different because the EU has a legislature, right? It's a complex legislature, but actually it's been quite prolific. So it has a legislature as opposed to the international regulatory environment, and also has the court. It has the Luxembourg court. So if there are any disputes as to the meaning of the common standard, it all goes eventually to the Luxembourg court, and the court has jurisdiction over that dispute. And then it has very, very robust mechanisms for cooperation among the EU 27 agencies. So yeah, so it's just a perpetual process.
Are there sort of takeaways you would, so it sounds like one takeaway is there may not be takeaways from the European mechanism of cooperation that we could apply more broadly in international cooperative efforts. What about some things you might emphasize over the course of regulatory cooperation between the United States and Europe? Are there things that you think are particularly cautionary tales, or things that you would sort of highlight as stuff that works or stuff that doesn't, or stuff that worked and stuff that might still work or something like that?
Yeah. So I'm far from an authority like Alex is, but I do think that, for instance, if you take an area that I know pretty well, which is privacy, there's that very long data privacy dispute going on between the EU and the US. It never seems to end. And there's very recently, it seems like there was at least a bookend to the most current dispute, and that's because there was a court that was set up within DOJ to essentially address complaints from EU persons that their data had been misused by the NSA and other kinds of other members of the intelligence community. And that was done to answer objections from the Court of Justice in Luxembourg in Schrems to the equivalency of the US standard for data privacy. And that was done because what happened was there was high politics that came in, sort of executive, political executive came in. It was the beginning of the Ukraine war, and the sort of high-level politicians were in Brussels, and they were able to hammer out together this court, which is not what we would consider a court, but it's very independent and it has all the markers of independence. So I do think that once you get sort of high-level commitment from the White House to fixing things, and to that is really something that can move cooperation forward.
Okay, well, there's a through line, high-level political engagement. I next wanted to talk to Jonathan Weiner. I'm not exactly sure how to do this. I see you over there. I'm gonna assume that you see me from here, so I'm gonna gaze into the void and ask you some questions, if that makes sense, Jonathan. So just a little bit more about his biography. He's served on the White House Council of Economic Advisors and in the Office of Security, Science and Technology Policy. He's an expert on risk, and I'm sure we'll talk a little bit about risk regulation in the United States and also in Europe. And he is also a public member of ACUS, so an important part of this agency. Jonathan, I thought I might start by asking you a little bit about your perspective on the role of OIRA. So you've thought a lot about how it works and how it doesn't, if it's something that other countries could benefit from, that it itself is an example or a model for international regulatory cooperation. And I guess I wondered how you thought about the role of OIRA in these sorts of processes. Hopefully.
Well, thanks, David. It's great to be with you, and sorry I couldn't join you in person. And I think it's, I want to say first, I think it's terrific that ACUS is returning to this topic. And thanks to Chairman Fois and to the staff, Kajia and others for, and you, David, and your co-authors of this report for mobilizing all of this. So it's great to be part of this study process. Yeah, I do think OIRA is quite important, and I agree with excellent points that Alex and Francesca made already. And I think OIRA is important, as Alex said, because it's the regulatory oversight body for the United States, and there are increasingly counterpart regulatory oversight bodies in other jurisdictions. In Europe, there's the Regulatory Scrutiny Board, formerly called the Impact Assessment Board, and more generally at the European Commission Secretariat and the Better Regulation Program, and also in the European Parliament, the Impact Assessment and European Added Value units, and then increasingly all around the world. And the OECD has been especially active in trying to promote and support regulatory oversight bodies, center of government mechanisms for reviewing and improving regulatory quality around the world. So that's a really important function and a really important set of transnational conversations. And if I could pick out two things that I thought from Alex and Francesca's comments that related especially to what I want to add to the conversation. Alex emphasized that OIRA and its counterparts and the regulators are the key actors. And Francesca noted that this is an ongoing process, not a one-off. So those are two key points for me, because after I left the government, after I worked, as you mentioned, at Council of Economic Advisors in the Clinton administration, I was fortunate to help work on Executive Order 12866, the team, of course, led by Sally Katzen. But then in academia, I worked on trying to study these regulatory differences across countries, US and Europe, and also other countries, and more recently, US and China. And so we held a series of transatlantic dialogues on precaution in the early 2000s, which were co-sponsored by the US State Department and the European Commission. And we produced a book and several articles from that on the reality of precaution, comparing risk regulation in the US and Europe. And what we found is that there are significant regulatory differences, but they're not just US versus Europe. They differ across different risks, health, safety, environment, food safety, air pollution, transportation safety, medical safety, many other arenas, and they differ within those arenas as well. And that variation is not just a matter of large trade blocs negotiating with each other, but of regulators understanding the different risks and regulations. And so what I wrote about that then, in not only in that book, but in an article in 2015 called The Future of International Regulatory Cooperation Toward a Learning Process and a Global Policy Laboratory, was that we really ought to think about these not as just trying to promote trade and harmonization as the goal, but as trying to promote learning, because in addition to the trade effects, as Alex mentioned, and as you, David, mentioned at the beginning, that purpose might be to facilitate trade, there are also domestic, social, environmental, economic impacts of these regulations. And whether we're trying to harmonize or not, we need to understand what the differences in outcomes are for the differences in regulatory policies. And that's not always clear. And even if one is trying to harmonize, there's a choice of harmonize to what? To, country A's standard or country B's standard or some third newer, better standard. So we need to seize the opportunity of these policy variations, these regulatory differences, to try to study what difference do they make in actual outcomes, and thereby have a learning process toward improving the regulatory designs on both sides, or in multilateral dialogues and internal regulatory processes. So that just returns me to Francesca's point. It's an ongoing learning process, and Alex's point, the regulators are the key actors. So back to your question, that makes OIRA and ACUS really key focal points for this kind of learning. Not only USTR or the DG Trade or the trade negotiators, because there's this learning objective and function in addition to the trade harmonization objective and function.
So am I hearing you as saying that you think harmonization isn't necessarily necessary, but engagement is? I mean, I guess I'm interested in knowing how you assess efforts to cooperate internationally that sort of don't work. And maybe I'm just restating what you said, or only works to some degree. I mean, what do you make of variation and difference? Is that something?
Well, sometimes the variations are regulatory differences that impose high costs to trade without significant benefits in protection of important values. And so that's what Executive Order 13609 talks about: unnecessary regulatory differences, not just smoothing out all the differences, but unnecessary regulatory differences. And I take that as a kind of approximation of a sort of a benefit cost approach to which regulatory differences are worth trying to resolve. But so there could be international regulatory cooperation that identifies regulatory differences and studies what difference do they make in social, economic, environmental, et cetera, health outcomes, and other values that societies care about. And that regulatory cooperation could work in the sense that you noted and Chairman Fois noted, and President Obama in his I think first inaugural said the question is not whether government is too big or too small, but does it work? So that IRC, international regulatory cooperation, could work even if it doesn't yield harmonization, because it could help us learn which regulatory standards have which outcomes, and then societies may choose their regulatory approaches, some of which could be harmonization. They say, yes, this difference was more costly than it benefited us. And others, they could say, we have different objectives or different needs. Maybe our societies are susceptible to different problems in different ways, or we're testing a different regulatory approach. And that could be valuable in an ongoing learning process. As I mentioned, even the drive to harmonization is not instantaneous, and it requires choices about harmonizing toward what common standard. So the learning process can proceed sort of longitudinally through that multi-year effort, even if it does lead to harmonization.
Can I ask you about climate? So I think of that as a very serious problem and a necessarily a cross-border problem. And I think you've had some experience working on climate-related issues. How do you think about that? Is international regulatory cooperation a mechanism to do that? Do we need to turn to international law and treaties? How do you think about regulatory cooperation in the context of climate regulation?
Yeah, so first, I did have some experience working on climate change, and here's behind me is a poster from the Framework Convention on Climate Change, 1992. So before I was at CEA during the Clinton administration, I worked at the Justice Department and OSTP in the Bush father administration, and helped negotiate the Framework Convention on Climate Change. And that's a topic I've tried to write about for many years and continue to. Just had an article come out last month in Texas A&M Law Review, reviewing the history of all of the climate treaty negotiations. So I think the first way that is important for international regulatory cooperation is that is another dimension of regulatory cooperation, is multilateral agreements and regimes on global objectives or global public goods. And when we talk about international regulatory cooperation, we often have in mind bilateral or multilateral dialogues about national regulatory standards that may differ, but we should also think about global cooperation. And then for climate change, of course, there is the arena of differences in national regulations, which might include the kinds of industrial policy or non-regulatory measures, industrial policy measures that Francesca was talking about, where there are potential conflicts over subsidies for, say, solar panels or electric vehicles or batteries or other climate-related industrial policy that have local content requirements, or other features that yield frictions over trade. And there's also the potential for regulatory measures that have like carbon border adjustment mechanisms or carbon tariffs or other measures that might specifically target international trade as a strategy to ensure the effectiveness of the domestic regulatory policy or tax and avoid leakage. And so, and I think, my colleague at Duke, Tim Meyer, and one of your colleagues on the your report, I think Kathleen, have written about that topic as well. So, to some extent, I guess I would add to the three changes that Francesca raised, as a potential fourth, the ongoing need to reconcile global regulatory policies to address global public goods like climate change, where there may be national frictions that arise in that process. But again, I would say sometimes that's a good learning process. Like sometimes the costs of those frictions may be worth the learning about which policies actually produce better outcomes.
Great. So now I'd like to, for the remainder of the time we have together, maybe get some questions or comments from people in the audience. And I guess that includes the online audience. And so I'm looking over at Kazia and Jeremy. Maybe you can let us know if somebody comes in and we can take a comment. So let's see, Jim.
Thank you. Years ago, when I got in this business, I learned really fast that you had to spend more time reading law journal articles than economic journal articles. And so when I went on tour with my musician friends, I would take these law review articles, I read them on the bus. One day I'm in a bus and I'm reading this article, and there's this professor wrote this story about how agencies tried to bypass OIRA. So I was very interested in that. And I remember at the end of the article, the professor says, agencies sort of bypass in the foreign, in terms of this law, executive order, where they go overseas and they negotiate a standard such that the standard will lock it in when they come over here. So when they go to OIRA, they have an international presence already. And I said, wow, that professor is really on the ball. So I kept on reading about it. And I thought it was very interesting. So I'm going to ask a question to this group. But before I do that, I don't know if Jonathan has any paisans, but the author of the article was Jonathan Weiner. I don't know if it's the same one. So with that background, I would like to ask this question. First of all, as I recall, part of the executive order directs the agencies to notify OIRA of certain developments along that line when they're going to work on some kind of international communication coordination. And my question is, and maybe Professor deals with EU knows this, a couple of years ago, there was this big push in Europe to regulate the social media. And I was directly involved in that. So I'm wondering if, as a result of this executive order and the directives, whether any of that came over to OIRA pursuant to the executive order, and what role anyone plays in looking at what that professor said, that it was a way to avoid OIRA. Thank you.
Jonathan, you want to take that first, or?
Sure. So just thank you, Jim, for the question. And what I'd really love to hear is the music you were playing on those bus trips. But I think that possibly the article you're referring to is one that I co-authored with Nina Mendelsohn, also an ACUS public member, and that we were actually responding to an article by Jennifer No at Chicago Law School. Jennifer wrote an article on agency self-insulation, and then Nina and I wrote a kind of commentary article on that, on how OIRA can respond to agency attempts to avoid OIRA. And in our article, Nina and I identified more avenues, more mechanisms that even than Jennifer had. So that you may find that discouraging that agencies may try to avoid oversight. And one of those, I think we had about 12 in our article. One of them was international cooperation, which a regulator could then bring back to their domestic arena and say, look, we've agreed this internationally. Of course, they would still have to go through, as Francesca and Alex were saying, they still have to go through the regulatory process like notice and comment rulemaking and judicial review domestically. By the way, this also can happen from the state, that is the federal regulator can work out an agreement with state regulators or some of them, and then present that as we've come to a deal. And I'm sure Alex could comment more on how that is manifesting nowadays. But one of the things that we said in that article that Nina and I wrote, Nina Mendelsohn, is this is an ongoing relationship. And so the agencies in OIRA are repeat players. It's not just a one-time defection by the agency that gets around OIRA. OIRA can see that and can monitor and can learn. And there's a repeated ongoing pushing and pulling sometimes, or more constructive relationship. And I'm sure Alex knows more about it than I do, but that was what we were trying to describe in that article.
I definitely want to hear what Alex thinks about OIRA avoidance. I'm sure he's very supportive. But you know, this phenomenon has always been a big problem for international regulatory cooperation. You know, if you do some deal internationally and you come back and put it through notice and comment rulemaking, the notice and comment rulemaking looks quite a fait accompli many times. So Congress has been worried about this. Sometimes they've, you know, introduced legislation to limit the ability of American regulators to go overseas and do deals. And you can imagine that the courts might take a dim view of that kind of approach to notice and comment rulemaking in the future. So I totally take the point. Alex, what do you think about, does OIRA get boxed in or boxed out by some of these efforts?
It has happened. It's well, I haven't. It's more like something you hear about just talking to folks in the hallways about what an agency did. Like they go broad, negotiate an agreement, appears to be legally binding, so they come to us with the rule. Our hands are tied. We can't make any of the changes you're asking or DOJ is asking as part of this interagency review. I just haven't heard of that happening. I'm not saying it's not happening. I'm not familiar with it. But it does remind me of State Department regulation that I believe is still in effect. And maybe the ACUS triumvirate could explore this as part of their review. I don't think a lot of people know about it. It applies to US regulators and calls on them if and when they engage in a negotiation with another government, there is a likelihood that the agreement would lead to a regulation that would need to be issued in the US, that they are to give notice to OIRA. OIRA is mentioned in this regulation. I'll send you the details.
Mm-hmm.
So, I mean, I think there's an awareness that this could happen. It has happened. There's this mechanism that attempts to address it. But it just, at least I don't have any firsthand knowledge of this being an issue recently.
So it's not that OIRA is dealing with this by sending people on these negotiations with the relevant agency or something like that.
No, we do not do that.
Other questions or observations, please.
Hi, Dan Mulaney, used to be at USTR handling Europe. I wonder if since regulators in the United States, and I think in Europe, usually have mandates, in our case, congressional mandates to do specific things like protect consumers, protect safety, protect health. generally those mandates don't include to make things easier for our trading partners. Is there a tension and a disincentive for regulators to engage in international regulation caused by their mandate, which is to protect U.S. consumers? And specifically, if an agency has a congressional mandate to issue a regulation to protect consumer, car safety, medical device safety, whatever, and the regulator has sort of made an arrangement, kind of a mutual recognition kind of agreement with Europe or another country that they're going to let their devices in, does that make that agency vulnerable to charges from Congress that they're caring more about the trade with the trading partner than they are about safety? And is that, I mean, I can appreciate that a regulator can do both things at the same time, both encourage trade and protect the consumer. But does that aspect, the fact that you have a congressional mandate to do something which probably does not include encourage trade, does that act as a disincentive for international regulatory cooperation?
Do you have a view on this?
I don't think you have a view.
I have a view on this. What do you think?
I'll defer to you.
No, it's a huge problem. You think about just one particular context, monetary policy, right? Should the Fed, so the strength of the dollar affects foreign economies quite a bit. And so should the Fed take that into account? They've said absolutely not. So it's a way in which, monetary diplomacy in theory doesn't happen because the Fed is focused solely on the interests of employment and inflation in the United States itself, knowing to a certainty that whatever the level of employment and inflation in the United States is going to affect, foreign workers all over the world. And so anyway, it's an illustration of a problem you've identified. I don't know, Alex, how do you think?
Jonathan also has his hand up.
Jonathan?
Oh, thanks. Yeah, just to give one example of what the question raised. When there was a mad cow disease epidemic especially in the UK, but also some in continental Europe, in 1999, US FDA adopted a very stringent restriction. Not only, it wasn't on eating beef, it was on blood imports from Europe, including by Americans who had spent time in Europe. And several of us in this room would have been disqualified under those rules from donating blood in the United States because of time we spend in Europe. And European experts on the precautionary principle were taken aback by the degree of precaution because there were no clinical cases observed, and even the transmission of the mad cow disease, bovine spongiform encephalopathy, or the human variant Creutzfeldt-Jakob disease, was only theoretical at that time. So the European experts were saying, where's your risk assessment? And I think, and there was also, an important countervailing risk in the United States, which is that restricting the blood imports from Europe, which are quite important in some cities like New York, could cause health problems at hospitals that needed blood and didn't have enough blood to treat desperately ill or injured patients. And FDA held hearings on this and so forth. So I think Executive Order 13609 or something like it, which says not only have regulatory cooperation councils and talk to your counterparts and have international regulatory cooperation, it also says consider the international impacts of your regulations. I think that's at least a helpful prod that helps the agencies and OIRA oversee. So in a regulatory standard like that FDA rule on blood had high health risks as well as not only trade restrictions, but domestic health impacts. That's one where I think something like, that was 10 years before the 13609 executive order or so. That would be a good example to try to address through that process.
Do you guys have views on agency mission versus,
I was just going to add that 13609 is explicit, telling agencies that regulations that result from international regulatory cooperation should be at least as protective as the regulation that would be issued in the absence of that cooperation. So it does set that floor and prevent the so-called race to the bottom.
Quick follow-up and then
I was thinking of a little bit the reverse situation to the mad cow disease one, Jonathan, you were talking about, say, for instance, FDA decides mutual recognition, they're going to accept the approval of a breast implant in France. So the breast implant material is imported into the United States, turns out they leak, they cause cancer. Now, in that instance, it seems like the agency would have been doing the right thing from a regulatory cooperation point of view, deciding that they had trust in the other agency to regulate properly, and say, okay, fine, if you approve this medical device, which I guess is what it is, then it's fine, that can be sold in the United States. Is there any scenario under which the agency, according that mutual recognition for that product, could say, well, we did our proper due diligence, and yes, I guess mistakes were made by the other side, but it's all in the spirit of international regulatory cooperation? Or do they get called before a congressional committee and get crucified for having trusted this French entity, which seemed like a good idea at the time, but subsequently it turned out badly, and it seems like the agency is then in a lot of trouble. And is the specter of that kind of situation a disincentive to the regulatory cooperation, or is there does the EU offer some kind of a safe harbor for those agencies to say, well, we did our due diligence, we did what was necessary, and sure, it didn't come out okay, but we did what we were supposed to do under our congressional mandate?
do we guys have brief answers on this, because we are at time?
I'll just say no.
All I would say is that political risk is a problem with regulatory cooperation, right? If you cooperate the politicians get mad about it. I mean, we've heard it, how important high-level political supervision is.
Yeah, I would just say, yeah, that is the example you illustrate is a downside risk of mutual recognition. And how do you develop the trust in the counterpart in the other jurisdiction? But it is also, in the case you gave of breast implants or medical devices or pharmaceuticals, there's a need for ongoing post-approval surveillance to see what the actual outcomes are. And that's something the FDA has to do regardless of international cooperation, right? Just when it approves drugs and devices domestically, there's a need for ongoing monitoring to see if the risks are worse than they thought.
I kept you here for 3 minutes longer than I meant to, so let's take 12 minutes and then reconvene at 11:15 to hear the next panel. But thank you, panelists, very much.
Hey everyone, it's 11:16. I'd like to get started again. I introduce our next moderator, Kathleen Clausen. I want to welcome a brand new ACUS staffer who's just starting today and didn't know I was going to do this, so I'm embarrassing her. But Kaiser Caldwell, wave to everyone.
Hi.
Yeah, very happy to have her here today. It's first day for you that we're doing this panel, so we're so glad that you're here with us. And warning, I'm going to do this again at the plenary session on the 13th.
Okay. I'll be
We're in
prepared.
bigger groups, so keep your smile going for a while. All right, the moderator of our second panel is Kathleen Clausen, and it's going to take a while because she's very accomplished. So she's presently a professor of law at the Georgetown University Law Center. She is the author of more than 6 works. And whenever I see that by a number of articles by a professor, I always say, I haven't read 6 works. I've written them. And they're the subject of trade, investment, international dispute settlement, and other related areas. She's acted as dispute counsel, or she's acted as counsel or arbitrator. Yeah, I knew dispute resolution was in there. Arbitrator in over 24 international disputes. Among other leadership roles, she served on the Executive Council and Executive Committee of the American Society of International Law and is co-editor-in-chief of the Journal of International Economic Law. Prior to joining the Academy, Professor Clausen was Associate General Counsel at the Office of the U.S. Trade Representative, and earlier in her career was legal counsel at the Permanent Court of Arbitration in The Hague, covering disputes between countries and investment law in arbitrations. She's a graduate of the Yale Law School, Queen's University in Belfast, where she was a Mitchell Scholar, and Indiana University, where she was a Wells Scholar. And I think that's, yes, we'll leave it there. I'm sure there's a lot more, but and she, of course, is a part of the big three, the triumvirate. And thank you for everything you've been doing for us, Kathleen. Thank you for moderating this panel, and I'll leave you to the introductions of the other panelists.
Thank you so much, Andy. That's again very kind, very generous of you. And yes, ChatGPT serves us all well, and we're using lots of text these days, and so we could all be as prolific as we wish. No, just kidding. I'm honored to be a part of the ACUS program, to be a part of the study. I want to thank the ACUS team for making this all happen, and my co-triumvirate colleagues here for coming along on this adventure. We've learned a lot in the last several months that we've been engaging with many different agencies in the government about how all of this works, and we're learning even more today. So we're grateful to have with us on this panel three colleagues online and who are overseas, or at least over a border. So we're delighted that you all could join us online. I'll turn to you in a moment. And with me here, you've already heard a little bit today from Dan Mullaney, who was formerly at the U.S. Trade Representative's office with me. So thank you, Dan, for being here, making time in your busy schedule. This panel is going to take a slightly different approach to the conversation, to the topic of the day. As you know, the focus of our study is on EO 13609. We got a good introduction to that, to its history, to how agencies think about international regulatory cooperation from our first panel of the day. Today, in this second panel, what we're going to do is turn to the role of international organizations, for one, and international trade agreements, on the other hand, in this regulatory cooperation story. So expanding our aperture slightly to think about how this all happens in these spaces, in addition to what regulators are doing under 13609. And so together, by the end, I think, of the panel, we'll start to weave together this story as to how all of these different components intersect and interact. So rather than me read bios for our very distinguished and accomplished panelists, I'm going to invite them to tell us, tell the group a little bit about their present or former work in international regulatory cooperation. What does your organization do? What does your what was your prior work, and how does it contribute to this space? All right, so I'm going to start with firstly with Sarah. And then from Sarah, I'll come back to the room to Dan, and then we'll go back online. So Sarah, take it away.
Thank you very much, Kathleen, and hope you can all hear me well. Good morning to you all there from Europe, from Rome in Italy, and it's a pleasure to join you here today. As Kathleen said, my name is Sarah Cahill. I'm currently a Senior Food Standards Officer with the Secretariat of the Codex Alimentarius Commission. And I don't know if everybody is familiar with Codex or not, but it's a commission that was established by the Food and Agriculture Organization of the United Nations and the World Health Organization just over 60 years ago in 1963. And it's essentially a multilateral forum where countries come together to discuss and to agree on standards related to food safety and quality, essentially with the aim of protecting consumer health and facilitating fair practices in food trade. My role as a Senior Food Standards Officer is to guide countries, I guess, through the processes we have in place to set standards and help them work within the processes and procedures that we have established. And I think it's, while it is specific on one area in terms of food safety and quality, I think it is interesting because it's a forum that has developed and expanded in its 60 years. It started off with 28 members. The US was there from the beginning, and we currently have 189 member countries that are part of the Codex Alimentarius Commission. But in addition, we have over 240 observers, which come from the other UN entities, but also intergovernmental organizations and non-governmental organizations who participate in this multilateral forum, but are not the decision makers. Essentially, the countries, the member countries are the decision makers. The standards developed are voluntary in nature, but there is a little kick in that when the WTO SPS agreement was adopted in 1995, the Codex standards were included in the SPS agreement as the reference standards or the benchmark standards for food traded internationally. So this means essentially that if a member of WTO is using the Codex standards, they are in compliance with SPS. So they kind of create a safe space. Of course, you don't have to follow them, but if you don't, then you need to have a justification for why you do so. So in the context of, I guess, of multilateralism, that there's a very strong connection between the work of Codex and what happens in WTO, and particularly the SPS agreement, and to a lesser extent, the TBT agreement, where they are a reference international standard. So Kathleen, I'll stop there. Thank you very much.
Great, thanks so much, Sarah. We just at the end of the last panel had a brief discussion about sort of how, standard setting at the international level, bringing those standards home, how that process works. So look forward to hearing more from you about that in a moment. But first, let me turn to Dan Mulaney. Invite Dan to tell us a little bit about, in 2 minutes or less, so to speak, your former work at USTR and how that fits with international regulatory cooperation.
Okay, well, as David mentioned, I'm the trade aspect of this. So I was chief negotiator for the US EU Comprehensive Trade Agreement, TTIP, Transatlantic Trade Investment Partnership, the negotiation I had with the UK. More recently, the negotiation we've had with Europe on the Trade and Technology Council. And those trade agreements all contain aspects of regulatory cooperation, including regulatory annexes where you put together regulators, and Steve Wood, who was in the front row, had front row seat at that effort when it came to automotive issues, but also disciplines on how you develop standards in an appropriate way, how you use those standards when it comes to referencing standards and regulations, how you recognize or do not recognize conformity assessments by the other side, and then more broadly, and again, a topic that was mentioned earlier, disciplines on good regulatory practices. And then before that, I was in Brussels for 5 years, and there I was a little bit tech adjacent, I guess I can call that, Transatlantic Economic Council, which Alex mentioned, and the high level regulatory cooperation forum. So I had a bit of a front row seat in the Brussels aspect of those negotiations. And then before that, a series of negotiations of mutual recognition agreements of various kinds, for instance, in organics, in wine, and in other areas. So that's my background, very much coming at the regulatory cooperation, regulatory disciplines from a trade agreement perspective.
Great, thank you, Dan. And indeed, I think what your comments highlight already is something that also is sort of percolating in panel one, which is the place of deal making in this exercise. So, sometimes I think those outside of this space, when you say regulatory cooperation, you don't necessarily think this is about agreements. And yet we do so much of this through agreement. And what's the significance of that? We'll come back to that shortly. Let me turn it over to Mariana online to tell us about what the OECD does in this space. Mariana.
Hello, thank you very much, Kathleen, and great to see a lot of familiar faces and to be in this conference. Although I'd much rather be there with you in person because the conversations are really interesting. So I'm Mariana Cartoon, and I'm working at the OECD the Secretariat, working at the Regulatory Policy Division. We serve the committee that works on good regulatory practices, and I'm leading work on international regulatory cooperation. And as part of this role, I've been working for a bit over 8 years on advising governments on how to implement international regulatory cooperation. So advising governments individually, but then also supporting committee discussions on kind of good practices on international regulatory cooperation. And as part of that, Alex Hunt mentioned, for example, a few recommendations of relevance to on international regulatory cooperation that have been discussed and adopted at the OECD. So I'll be happy to get into that, but that's me in a nutshell. Thanks.
That's great, Mariana. Thank you. Yeah, we could not have this conversation without OECD represented. So delighted that you could join us. We'll get more into your work in just a moment. But first, let me pass the floor over to James, who now also coming back across the Atlantic, a bit north of here, however, to tell us about where he sits and what he's working on in this space. James.
Thank you, Kathleen, and good morning from Ottawa, Canada, where it's a bright, sunny day. My COVID lemonade is to be able to work outside from time to time, so I'm selfish about that. I work as Executive Director of Regulatory Policy and Cooperation. So regulatory cooperation is right in my title at the Treasury Board of Canada Secretariat, and we are responsible amongst other regulatory policy initiatives for supporting 3 formal regulatory cooperation tables. The first one since 2011 with the United States, the Regulatory Cooperation Council. The second one under the Comprehensive Economic Trade Agreement with the EU called the Regulatory Cooperation Forum. We also have one domestic table with our provinces and territories called the Regulatory Cooperation Table. So RCC, RCF, RCT, there'll be a test at the end of the panel on which is which. And in that, we are the champions for regulatory cooperation. Built into our cabinet directive on regulation as regulatory proposals come forward for cabinet or treasury board deliberation. One of the tests is, can this regulatory proposal be met through regulatory cooperation, or are there key regulatory cooperation considerations as the proposal comes forward? So before any proposal is approved by the executive branch, there's a regulatory cooperation test that's done in advance as well. So lots of work there, and looking forward to the panel discussion, Kathleen.
Thanks, James. Well, let me stay with you, if I may, James, as we get into now, after we've had that helpful overview from all 4 of you about what it is your organization does, where you fit into this broader system. Sticking with the Canadian experience for a moment, and you mentioned the 3 tables, James, very interesting. I've got my acronyms for our later test. And in a way, I think it sounded like what you described was a little bit akin to what OIRA does on the US side, some of a similar role at least. And so I don't know if that's exactly how you would characterize it, but maybe you could tell us a little bit about, just drawing from the 2 bilateral experiences you mentioned, the one with the CETA, the one with the European Union, and then the RCC with the United States. How have those experiences come about? What lessons have you taken from them, or what should our audience, what should we take from your experiences there in those bilateral regulatory cooperation settings?
So our regulatory cooperation, I would say, relationship with the United States, the formal, again, RCC is the most long-standing. And again, to your point, Kathleen, OIRA are our counterparts or our partners in those conversations. Treasury Board and OIRA would form the secretariat for that council. It's a deputy minister level. So the administrator of OIRA and our secretary of the Treasury Board would be co-chairs of that council, and have had a healthy dialogue and a great partnership since 2011. That was a political decision between former Prime Minister Harper, and a former President Obama, in terms of spearheading the need for that type of cooperation to happen across the border between our 2 jurisdictions. And I would say certainly from that model, we've brought that forward into many of our trade agreement discussions around good regulatory practices with other partners. And so while the table construct with the EU is a little different because every jurisdiction's a little different, I would say the RCC was probably the starting point for, again, championing that formalization, both politically, having that political oversight, and I think that was a conversation in the last panel, but also then you need the bureaucratic apparatus underneath it to follow through on that political direction in terms of moving things forward and making sure that the work is advancing. And so the RCF is one of many bilateral committees underneath the Canada, or the comprehensive economic trade agreement with the EU, and as well.
Yes, hanging. Just a moment.
It's very interesting for me to be sitting between two very large economies. So now, sorry, I'm getting a signal that my internet connection is unstable. Am I rocky?
Yes, not a commentary on our bilateral relationship, but no, we did lose you for a moment there, James.
Oh.
But you came back when you were saying about the relationship between these two very big economies. So maybe there was something.
Sometimes I feel caught. Very much caught. So it's I could probably spend an hour talking about those feelings when the EU wants something and the United States wants something. But I would say in terms of lessons learned from both of those tables is that industry or business on both sides have to be telling government the same thing. It can't be one-sided driven or one economic benefit for one jurisdiction over the other. So, for example, with our partners in OIRA, we want to make sure as we're moving forward on any dedicated work plan items that American business, the American trade, the American economic imperative, and the Canadian economic imperative are saying the same thing in terms of what's the business case for this regulatory cooperation. Otherwise, I would just define it as an irritant. Canada wants, Canada wants, Canada wants. You have to have that partnership. You have to have that partnership and that open dialogue between the regulators. And so it's almost like the formula for success are OIRA and TBS are saying the same thing. The two sets of specific regulators are saying the same thing in our governments, and then industry business are saying the same thing, and that sets us up for success in terms of moving forward. The second thing I would say is that underneath all of these formal tables, and it's very important to stress this, and it may have come up earlier, but regulatory cooperation is going on every day. And you don't need these formal tables to get in the way of that. In fact, you want to stay out of the way of those relationships, and you want those positive dialogue and interactions and exchanges to continue. And sometimes we can actually add an extra layer of bureaucracy that actually isn't helpful for them. And just 9 times out of 10, we're there to help you get over the line, to give some political attention, to give some energy, to give some bump. But it is going on every day. And we hear about that. We are told, actually, we'll do a call out, any good items, and we'll say, our relationship's good. We don't need any help from TBS or OIRA. And then the third thing I would say is, and I'm not sure if the distinction came up earlier, but we look at cooperation actually under 2 terms. Reconciliation, which is looking back at rules that are already in place, and what do we have to do to sort out the disharmony or the misalignment between those rules. And actually regulatory cooperation is more looking forward about either emerging technologies or emerging sectors. And it is much easier to work together. We think it sounds like a lot. It's very hard to do coordinated future looking standard development. It really is. But it is much it's a much better outcome if you can sort out the forward looking and avoid as much misalignment as possible than to look backwards and sort of like, I call it, you know, good hygiene, like take the floss and get the plaque out of the system. That's a lot of work. It's very, very, very challenging because people get entrenched with the rules that they like and why they like the rules and why those rules have to be in place. And then that causes that those aren't as constructive conversations sometimes. So I'll leave it there. Everybody has to be on the same page, regulatory cooperation going on every day, and cooperation going forward, even though it's a heavy lift, is a much better outcome than trying to look backwards and fix misalignment problems.
Terrific. Thank you, James. I'll come back to some of the issues that you highlighted there in a moment. But first, let's hear from Dan, because Dan, you also had this bilateral experience, right? That working so closely with the EU, and that evolved over the years that you were there, no doubt. You know, I remember when we were at USTR together, it was, you know, the big TTIP days. Now we talk to Trade and Technology Council. What is this thing? How should we think about that? So what are your lessons learned from those relationships?
Yeah, thank you. Yeah, the few lessons learned. One is that everybody seems to think this is easy, regulatory cooperation between the United States and Europe. And even at high political levels, people get together, they say, you know, I go to Europe, I rent your cars, I feel safe, I eat your food, I feel safe. You know, you come to the United States, you eat our chlorine chicken, nobody dies. You drive in our cars, nobody dies. Well, seldom do people die. So, right, we should just mutually recognize, right? So at the high political level, you have that drive, and of course, then you get down to the details, and it ends up being really, really difficult. And there is a bit of a dynamic between the political side, I think, and the working level side. The working level trying to do, in our case, what Congress mandates, which is to, you know, protect consumers, protect U.S. citizens. And on the EU side, the same thing. They have their own objectives, which are both to protect consumers and do the normal things that you expect governments to do, but also to complete the single market. Huge focus in Europe, you know, compared to the United States, on, you know, completing the single market and making sure that that differences among member states are smoothed out, which frankly then leaves arguably a little less room for working in views of trading partners like the United States. The second lesson I learned is that you know, it helps to have some great initiative to move things forward, some momentum to move things forward. And I think in the earlier panel we were mentioning high-level political interest. We started the TTIP negotiations, the Transatlantic Trade and Investment Partnership negotiations, because we thought, well, you know, we had the TEC, Transatlantic Economic Council, we had the high-level regulatory cooperation forum. They were making good progress, but it was kind of a bit slow and meandering. And there was a thought, at least at the political level, that we needed to sort of supercharge that discussion by having a comprehensive trade agreement, which that dealt with a broad range of issues, including the regulatory cooperation pieces, and including some of these issues that I mentioned earlier, like standards and conformity assessments and good regulatory practices. And I think that actually bore itself out. I think, you know, the TTIP negotiations for the several years that it was in operation did push forward a lot of regulatory cooperation, regulatory discussions that hadn't been happening quite as much. One can argue about, you know, whether they were dealing with the big issues or a lot of different small issues, but it did create that momentum to move things forward. So that was my observation. Of course, the subtext is it moved everything forward until suddenly it didn't, and it didn't in part because, you know, TTIP did not continue. And one of the reasons that one of the myriad reasons that TTIP did not continue was a little bit of backlash from the NGO community and others. It's related to my first point. So you can create the momentum of regulatory cooperation moving forward as part of a trade agreement, but then you also create the potential risk from the NGO community and from consumers that you're maybe pursuing these objectives to benefit trade, as opposed to benefiting the consumers, to benefiting the climate, to serving the legislative objective. So the trick, I think, has always been to communicate that, yes, we're moving forward very aggressively with a trade agreement that includes regulatory cooperation pieces, but it is very much focused on the role of the regulator. It is very much focused on achieving the regulatory objectives. And that is sometimes a hard message to sustain. And those who are against trade agreements find it easy fodder to say, well, you're just doing all these things so that you can increase trade. And as I think someone said earlier, it's maybe a bit of a secret deregulation agenda. The other thing, so that's an issue I think that has to be managed going forward, creating the momentum for regulatory cooperation without creating the impression that you're undermining the regulatory objectives. The third thing I learned, and this is, I think, very Europe specific, perhaps, is how many of the complications regulatory cooperation between the United States and Europe have to do with the asymmetry of our systems. So I mentioned we had several different legs of our regulatory cooperation. Putting the regulators together to talk about recognizing good manufacturing practices or recognizing substantive rules of automobiles or medical devices or what have you. We had disciplines related to how you develop standards, because standards are often referred to in regulation, and so compliance with standards is often compliance with regulations. We had discussions on the use of standards, how you use standards in regulation, and the kind of presumptions that you give to the standards. We had disciplines on conformity assessment. One test, do you recognize the test of the other party? Good regulatory practices. Notice and comment. Does the regulator provide an opportunity for notice and comment? Which, of course, even in a cooperation context, allows the other party to comment, maybe even get potentially a privileged position in commenting on proposed regulation. But when you're dealing with the EU, it's a bit of a transnational organization. Something as simple as good regulatory practices. Well, on the EU side, if they're developing regulations, it's really more of a it's more of a legislative process. You get the 27 DGs on board, then you get the 27 member states on board, then you get Congress or the Parliament to vote, and then you have the rule in place. Well, where in this process does the US come in and have its input? Before the DGs? Don't think so. Sorry, these are director generals within the European Commission. Does the US get a say before the member states get a say? Yeah, that's not going to happen. After the member states look at it and they've reached some broad agreement where you get Sweden to agree with Bulgaria, to agree with Finland on these things, at that point, frankly, the cake is a bit cooked. There's not a lot of entry points. So even something as simple and maybe obvious as good regulatory practices, on the US side, we can have a broad mandate to regulators and then have a situation where there could be notice and comment, to take the comments into account. The EU doesn't have quite that system. It's a bit in the same way when you talk about regulator to regulator conversations. Well, we have the US regulators sitting at the table. They have EU counterparts across the table, but who's actually doing the regulating? Often the member states. Where are the member states? Mostly excluded from the room. Because the EU's view is, no, we do this with the United States. We do international trade with the United States. But of course, if you're the regulator, you don't care what DG Comp says or DG Sante. You want to know what the entity in Germany, in Sweden, in Bulgaria is doing. And so there's that disconnect between the authority of the member states and the authority of the Commission. And you also have a policy impulse on the European side, which is fully comprehensible, towards supporting the internal market, which is to say, no, you deal with us and you're going to mutually recognize good manufacturing practices, for instance, on behalf of the whole EU. And of course, our regulators are saying, well, I don't know, we can have a conversation with the Swedish manufacturers, and that might be a different conversation from the Bulgarian manufacturers. I don't mean to pick on Bulgaria in this context, but you get my drift. Each member state, from the US regulators' perspective, who is charged with protecting safety, they very much want to know who the manufacturer is and have that make that decision probably more on a member state or even a facility by facility basis. Whereas the EU says, no, we're in the internal market. If you agree with us, that covers the whole EU. Not really something that works terribly well. A little short on time, so just mention, when it comes to development of standards, Europeans develop more regional standards, which they then use for presumptive conformity with their regulations. We have much more of an approach of looking at open consensus standards, which provide more opportunity for input. And so, when it comes to reaching disciplines on, can everybody participate in everybody's standards development process? The answer on the EU side is not 100%. And for very good reason, because they're trying to complete the internal market. It's a tough enough job, getting Bulgaria, I don't mean to pick on Bulgaria, if anybody here is from Bulgaria, getting Bulgaria to harmonize with Sweden, that's a big enough job without having to, harmonize or whatever with the United States. So I think that the bottom line lesson I learned from all of that, and I've got lots of other examples, which I won't bore people with right now, is that it's complicated. But if you look at each phase, each part of this, and get into the details, I think you can find areas where you can have meaningful cooperation. And it does not mean, I go to Europe and drive their cars and vice versa, therefore let's recognize auto safety standards. It doesn't work like that. But you can, for instance, say, well, maybe there is an opportunity in the EU legislative process for some input on the US side. Pick your point in the process. Maybe when it comes to the use of standards in Europe as serving as presumptive conformity with European regulation, maybe there's a process for allowing US-based standards or international standards to also create a presumption of conformity. So I think once you get into the details of the differences, and there are huge asymmetries between the institution of the European Union and a sovereign country like the United States. If you get into the details of some of those very big differences, I think you can draw those lines, but it has to be some degree of detail, has to be some degree of nuance.
Yeah, great. Well, thank you, Dan. So I mean, there's again so many follow-up questions I would wish to ask you, especially comparing, your experience to that of James. But I do want to now sort of take us from the bilateral to the multilateral. Now, Sarah, you said 189 members, if I heard you correctly, right? That's speaking of challenges, I mean, Dan put a few on the table. You have many challenges, I suspect, in what you do. And I also I'm thinking about what James was talking about, the reconciliation aspect of how that can be easier or harder versus the forward looking. Tell us a little bit more, if you would, Sarah, about those challenges in the multilateral space and what seems to work or smooth the way.
Yeah, thanks very much, Kathleen. Yeah, indeed, bringing 189 members together has its interesting points. And Dan mentioned the EU, and we have the Commission, but also the 27 members who are all members of Codex. So they're all at the table, and they have to tell us in advance who actually has competency, whether it's the EU or the member countries, so that we're clear who's negotiating on each particular issue, because it does vary depending on the topic. I think going back to some of the things James said are challenges, he said trying to set standards and things that are already enshrined in certain countries is can be very challenging. So if you're looking backwards, and some big countries, some high economic countries may well have standards on many of the issues we're covering on, but we may have 100 and something members who don't have standards in those areas. So we still need to focus on those. So this is why they still become part of the agenda, and it's important for us to work on them. And I think this is where it's important when people come to the table that they see the difference, I guess, between what we're trying to do in a multilateral forum like Codex in terms of developing standards, and that you're not trying to necessarily say everybody has to be the same, because we're saying the standards are voluntary, so it's up to you whether you adopt them. But we're trying to help those who perhaps have no regulations in a particular area to have a standard that is sufficient to protect consumer health, that will somehow facilitate trade, and is based on science. And I think what has been a great starting point for us is to say that our standards should be based on science and risk assessment, and having that sound basis on which to establish a common ground, because I think if we all agree on this, the science or the availability of science, then we're already a long way through the pathway. And we have had occasions where everybody agrees on the science. It doesn't mean we'll agree on the final standard, but we agree on the science, and it gets us a long way, particularly when we're coming to food safety issues. But if you don't have a standard there already, you know, it can be super fast to make progress. I'll take an example. It's an old one now, the adulteration of foods with melamine, for example, that emerged 15 years ago. At that time, nobody knew how to manage this issue. Nobody had a regulation or a standard. So within 1 year, we were able to bring the scientific community together through FAO and WHO, and then come into Codex and establish a limit for melamine within 12 months, which is super fast in Codex. Normally, we take maybe 4 to 5 years to develop a standard. And so it just shows that if there's nothing there and everybody has the same objective, essentially here, our goal was to ensure that trade could continue while at the same time protecting consumer health, then things can go really quickly. There's a lot less hurdles in the way of making progress. But I think the other aspect of the forum is that you know, we come together. Our goal is to set standards, but at the end of the day, it's about bringing people together in a multilateral environment to actually discuss and share information. So a lot of the benefit we see is that people can actually just exchange information on what they do and how they manage particular issues. This already helps us to, again, find another common ground. We won't go into, or we can't go into extreme detail in our standards. If we try to do detail, we would never agree on anything. So part of the process, I think, of finding common ground is also having clarity in terms of what it is that we can achieve as a multilateral standard setting organization. So if we agree on a clear scope and what we want to achieve in terms of an impact at the beginning, we're much more likely to succeed than if we don't. And often that comes from sharing the challenges individual members have, or the expectations that people have from a particular standard. So in some areas, we will set, for example, quantitative standards. So it will be a bright line standard, it will be a number, and these we very much depend on science to get agreement on, and that can work well. But there's a lot of other areas. We heard mention of good hygiene and things like that, where we try to provide a framework. So it's a more code of practice or a guideline whereby members have they agree on the framework, and then the details can be adapted to the local context, because we can never provide that level of detail to the extent that 189 members would be able to agree on it. I think Dan mentioned, you know, chlorination of chicken. That's something I don't think we would ever probably get agreement on Codex, but we were able to find a way to recognize that within our good hygiene practice, or within control of certain pathogens, to recognize that this could be an option in some countries, but recognize that others may not achieve it. So sometimes it's a matter of finding a language where we're able to recognize that different approaches may be taken within countries while still agreeing on an overarching framework that's agreeable to everybody. And perhaps one other point to mention here as well is about processes and procedures. And I think if we have a clear process on how we're going to develop a standard at an international level, and a clear process by which we do it, this makes everybody more comfortable with engaging in the process. So we have our rules of procedure, we have a kind of an 8-step process, and this provides clarity to people on when they can engage, when members can engage in the process, but also observers. So when observers can provide input into the process, and these observers represent, in many cases, they represent the key stakeholders like the industry, or they may come from academia, or they may represent consumer organizations. So we have a step-by-step process for standard development, which clearly outlines who can provide input and when, and the way in which you can do it, whether it's showing up at a meeting and raising your flag, or providing comments in writing. So by having all that laid out as well, it gives everyone the sense that they have the opportunity to contribute one way or another, and levels the playing field a little bit, I think, in terms of input. It's not perfect, because the easiest way in many cases is when you can get everybody in the room and they can all talk to each other formally in the session or informally in the coffee breaks. But we've had to learn to adapt a lot over the last few years and find other ways of doing that. And just, I think, people recognize that even being able to follow a conversation through a webcast or something and hear what other people's concerns are can already help us move forward a lot. So so I think, yeah, again, looking forward, it's much easier to look forward than go backwards, but we need to recognize that not everybody is the same as the US or the EU, and so we have a lot of standards to set that'll help bring everybody a little bit closer to those other countries. And I think then finding optimal means of communication and understanding our challenges, because often they're usually not that different. You know, we have some areas where, of course, there's very strong views held. The use of growth promoting hormones in meat production, for example, is something where there's very strong views, and we could not reach consensus in Codex on that. We had to have a vote on the final decision, and that's highly unusual because in most cases we can actually agree our standards in a consensual manner. Some members might say, well, they might reserve their position because they might not be able to apply them immediately or for various other reasons, but generally we will reach consensus. Occasionally, like in the growth hormones issue, we will have to have a vote. But nevertheless, I think it's important that we use those tools or procedural tools that are there to help us to come to a conclusion, because what's really disheartening is that you continue going around in circles and never coming to a conclusion on an issue. Finding an endpoint is important for everybody, and it feels that their time is not being wasted in this process.
Thanks, Sarah. It's very important points there, and good lessons to take from your experience, particularly on your last point, that of where cooperation is not possible. Where does that leave us, where we're not just hanging out there, so to speak? Maybe we end up in a dispute context, but hopefully not. And yeah, we'll be curious to hear others' views on that issue as our conversation proceeds. Let me ask Mariana to come in now and maybe expand a little bit, if you would, Mariana, on what you said at the outset about the role of OECD in this space, in the present regulatory environment. And again, as I said to Dan, sort of that's also something that's changed over time, surely, your role and maybe where you see governments needing more help these days. Where are they embracing this philosophy, or where do you feel you're sort of dragging them along? Welcome your views on those points.
Thank you. Thank you very much. Indeed, I think this is especially useful to be speaking after Sarah, I think, because it's good to underline how different our organizations are and how complementary as well different organizations with so different mandates can be. So just for those of you who don't follow the OECD so closely, it's for memory, it's an organization that brings together only 37 member countries and which are rather on the kind of more developed end of the spectrum, with more developed economies and more advanced institutional frameworks to engage in kind of structural reforms. And I think the kind of common traits nowadays within the OECD is to have more common values and being aiming to be at the cutting edge of policies in addressing global challenges, as opposed to, at least in theory, being easier, a better form to achieve, or easier way to achieve kind of consensus because they're less member economies. And so on regulatory cooperation, perhaps I would say there are two ways in which the OECD plays an important role. The first is really on international regulatory cooperation specifically, and on good regulatory practices in general. So basically on the how, and basically how to conduct regulatory cooperation. And on this, the OECD has, I mean, I mentioned before, and I think Alex Hunt also mentioned, that the OECD has been enabling a kind of exchange of experiences between its members since the early 2000s, really on how regulatory cooperation is an important component of good regulatory practices, basically considering international impacts within impact assessments, considering also international standards, but also cooperating through mutual recognition agreements, participating in international organizations, etc. And this has led to over the past 10 years, really the setting of a normative framework on international regulatory cooperation with, I would say, 3 recommendations, which are the kind of most legally binding instrument before, well, they're not formally binding, but they're the most advanced instruments within the OECD before a treaty. One on good regulatory practice, regulatory policy and governance, and that has one principle on regulatory cooperation that was from 2012. And we have one recommendation adopted in 2021, which was for agile regulatory governance to harness innovation. And that one includes in particular recommendations to cooperate, especially in issues of more innovative policy issues that come up with technology advancing quickly, with the need for better anticipation, with policy challenges evolving at a higher speed than regulators can keep up. And here, I think James's point earlier about the importance of cooperating, especially on issues where there is not yet an established kind of legal and normative framework nationally is perhaps even more crucial. And the third recommendation is a recommendation adopted 2 years ago, really on regulatory cooperation to tackle global challenges. And that one is very much based on work conducted, among others, under US and Canadian leadership. So very much mirroring the models that have been presented to us in the last panel and right now as well, on how to incorporate international impacts within domestic rulemaking, how to participate better in international fora and cooperate better between regulators, but then also how to establish the necessary governance structure with agencies such as, or bodies such as OIRA, such as the Treasury Board, that oversee all of this and that ensure the monitoring of regulatory and the actual carrying out of regulatory cooperation. So I would say that initially the role of the OECD was really to set that framework and to guide countries in how to conduct regulatory cooperation. And now, perhaps moving forward, there are 3 areas I think that the OECD could go, also drawing from the fact that the OECD has an expertise that's much wider than public governance and regulatory policy, is that the OECD now has this normative framework saying that what are the good practices on regulatory cooperation. It has the committee that's monitoring, or that at least enables countries to exchange their ongoing experiences. It has a steering group on regulatory cooperation. And we even have indicators on regulatory policy and governance, including indicators on IRC that allow to see in time how much countries are actually implementing regulatory cooperation. So I think there's the first priority could really be into a better and more ambitious monitoring of how countries are implementing regulatory cooperation. Here, taking into account the fact that, again, we have not only the actual normative framework, but also the members that are leaders in this space, the champions on IRC, and who can really push other countries forward on this. The second, I would say, and precisely because there is a relative homogeneity in values across OECD members, taking into account, of course, the very good points by Dan about asymmetries between systems, and very conscious of the difficulties here. But let's say from a multilateral perspective, one of the things that the OECD could help doing, at least from the international perspective, could be to help members prioritize their IRC efforts, in the sense that OECD or other organizations actually, or different organizations together, but at least the fact that there are multilateral discussions going on and multilateral spaces for governments to identify where cooperation already exists and where it may be lacking. That can also be a way to prioritize where the major risks are and where more cooperation may be needed. And that can be a way of like precisely complementing a bit the what to cooperate on and then the how that we've guided the members on until now. And finally, the last point I could say, and this may be coming a bit closer to what Sarah and what Codex is doing, is that the OECD can then also help precisely play this role of a sounding board between the smaller number of member countries agreeing on specific points, on points on which more like-minded countries can agree on, and then moving agreements from the OECD to multilateral levels. And this is something that it's done in several areas. That certain, and then of course, certain issues are much better adapted in other fora. This is the OECD agreements within the OECD is not an end in itself, but it can be kind of an incubator for certain ideas to then evolve in broader settings. And I think on that, we work a lot with APEC, for example. We do a lot of principles that are developed at the OECD, then in APEC, then together, and then taken to other fora. So this is another avenue that I think could go on. I think I've spoken a bit over time, so I can go on for a long time, but please stop here and let me know if I can.
Thank you so much. Thanks, Mariana. That's great. And as you said, I think we could have this conversation for the whole day, or at least some of us here who feel close to this topic share that with you. And some of the last thing you said there, I think made me think about a question that has been under the surface maybe for a lot of what we've heard, especially listening to you all in this sort of sequence, is what's the best vehicle for doing some of this work, right? When do we go to the multilateral setting? Should there be a codex equivalent for, X area of regulation and Y and Z and so forth? And when do we do this in the bilateral space? And that's more effective. So a lot to chew on there. But I want to switch gears slightly to do a little, two little maybe round robins with our panelists before we open to questions. The first is going to be about politics. And I'll let you all interpret politics as you see fit. David opined earlier today sort of about the maybe changing direction in the United States, about how whether we're talking sort of about free trade and protectionism, that sort of feel in politics, or something else, right? When politics change, how does that affect international regulatory cooperation from where each of you sits? So I'd like to hear, maybe I'll start with you, James, because I think you really teed this up for us best. Your experience in navigating the politics, when someone said earlier, it's about it creates momentum. How is that manifested in the work of the Treasury Board? How does that lead to particular institutional outcomes or prevent them? What's been your experience, James?
Well, I think that the experience has been generally positive. I mean, it creates work for public servants, and it certainly we can be at a scramble in terms of catching up sometimes with the political conversations. But I do think that shining a light politically on the need for regulatory cooperation, and that there's potential misalignment across a border, and that again we're going to pay political attention and give this some momentum and some energy, is always helpful in getting issues over the line. I think for us and our relationship with OIRA, and again, regulators are communicating all the time. A lot of it is the convening of the industry stakeholders and making sure that there is that there isn't just, again, the political alignment, but there's the economic alignment discussion that's going on both sides of the border. That, again, the business case is sound for both the United States and for Canada. And then again, we have that political direction, and the bureaucrats can take that political direction and implement various work plans, etc. We haven't had the same political attention with the EU. So to Dan's point, the EU Regulatory Cooperation Forum with Canada is co-chaired by 4 directors general. Myself, I have a colleague at Global Affairs Canada, which is our foreign affairs and trade colleagues, and then it's co-chaired on the other side by DG Growth and DG Trade. And it moves at a very different pace. And at times, maybe a little bit of political attention could be helpful. At the same time, we've had a long history of trade cooperation, economic cooperation with our cousins to the south, across the Atlantic. And again, to speak to Dan's asymmetry, I'm gonna steal that, Dan, because that's I'm learning something every day. I think it has taken us a number of years to build trust in just the process that we have about discussing these issues in the same terms, from the same value system around risk, around science, Sarah. And we've been focused for the past 3 or 4 years on those really, really, really nitty-gritty, backward-looking reconciliation issues. And it's only now that we're sort of pivoting with the EU and talking about the forward-looking pieces. So I think for us in general, the political attention helps. It brings energy to the conversations. It certainly gets business and industry excited, maybe over raises expectations about what can be accomplished in a short period of time. But I don't, that's their job. That's why they're elected, and we need them to do that.
Thanks. Mariana, can I come to you next? I mean, again, the question of politics in the OECD must be ever present. What does that mean to you?
It's a difficult question. I feel like debating it in my head since you asked it, because it's true that absolutely I would agree with James that there's clearly nothing really moves forward if there's no political attention. At the same time, if there's too much political attention, it can really halt things and avoid it from going forward. And I think if I would really encourage to think of IRC as international regulatory cooperation as a spectrum of different forms of cooperation that range from international treaties to mutual recognition agreements, to voluntary standards, to then just exchange of information between within a cooperation council, or just even informally between regulators. And I think that if one considers it like that, it's more helpful to think of regulatory cooperation as something that can happen on a continuous basis, regardless of the political attention, and something that should be happening all the time. Because if we do work around the premise that there are global challenges that all of governments are looking at and need, or at least need to be looking at in the same way, there should be really regulatory cooperation, whatever the political agendas are. So I would really think that that this spectrum approach encourages a more continuous regulatory cooperation beyond political agendas. Beyond this, I think still one thing that may be helpful to think about is that the in the OECD context, the regulatory cooperation has received highest level of political attention at some points, and now is rather in a stalemate. So or in more of a it's for the experts now to conduct. So I think that's and I think that seems to be what I'm hearing also from perhaps Oira and perhaps James in a way. I don't know if you would agree with that, but perhaps now is the time where the machinery and the bureaucracy that James was mentioning needs to kind of continue doing its work while until the next political momentum comes up. I would say.
Thanks. Yeah, I'll come to Dan in a moment, but Sarah, does that resonate in Codex? I mean, do you have the same sort of influences or feelings there?
Yeah, I think very similar to some of the things James and Mariana said. I mean, without political attention, we wouldn't be able to work, right? So, I mean, we depend on members being able to engage in this, and there's a cost to that, and there's a resource required to enable that. So there needs to be a certain amount of attention to facilitate that engagement. And as well as just engaging, it's also the nature of the engagement, right? So that can be changed depending on the nature of the political engagement or political attention. It's not just enough for us for people to show up in the room. People have to be willing to work. We require people to have the necessary support within their own governments or country to take on pieces of work and bring them forward and drive a discussion in a certain area. And so they will only be given the time to do that if there's a political commitment to this kind of multilateral engagement. So, but I agree with Marianne. You know, if you have too much political attention, it can drive people to have very high expectations of what we can achieve, and people are maybe less willing to compromise. So there's a right level somewhere that allows people to engage, but also creates an environment where people are all working towards some kind of harmony or compromise standard that they can all live with.
Thanks, Sarah. Dan, we're what, 3 blocks from the White House, another 15 from the Hill. What's your experience? Do you agree with what has been said so far?
Yeah, but I do think that both our global challenges and the current politics on both sides of the Atlantic are really creating a watershed moment. Because, you know, we have a climate crisis, we have a supply chain vulnerability issues, we have concerns about the digital environment, and all of these things are creating a need to regulate, to protect the environment, to preserve supply chains, to control the digital stuff, energy policy. I think whenever you have this, and more broadly, industrial policy. So you have something like the Inflation Reduction Act in the United States, or you have the CBAM, the Carbon Border Adjustment Mechanism proposal in Europe. All of these, the politics requiring these regulatory initiatives to address politics and also global challenges, I think create a dire need for some regulatory cooperation. Because you have a proposal like CBAM, Carbon Border Adjustment Mechanism, it can turn into a cooperation activity to prevent carbon leakage more broadly, or it can turn into a trade war. You can have the Inflation Reduction Act. It can lead to cooperative efforts on how and whether to subsidize or support certain industries, or it can lead to a trade war. So I think we're really at a moment where there's enough legislative initiatives out there driven by politics and in part driven by global challenges that it's really, it's kind of a moment for international regulatory cooperation.
Thank you, Dan. That's great. I'm going to hold my question because I'm cognizant of the time and we only have 8 minutes, and I know there are going to be questions in the room. So, and if not, I will come with my own. And I'm also watching, Jeremy, you'll throw something at me if there's anything online. Folks online, do feel free to put a question in the Q&A box if you wish. Questions from those in the room? Want to ask anything of our experts? Okay, then I'm going to go with my own, and more
We were so,
time.
we were so thorough.
Yes, you were. Well, let me bring this back, if I may, panelists, to the starting discussion with the EO, right? With that, again, I mentioned at the outset, those of you who are here, you know that our study is very much focused on the evolution of Executive Order 13609, directing US executive branch agencies to consider international regulatory cooperation in their policymaking, among other things. So I suppose I would just invite your comments reflecting on that initiative. Is this experience on the US side, which now is over a decade old, right? Is that something unique? Is that then spurred similar initiatives? We heard a little bit from Francesca on this point this morning in other places. Where is the US maybe ahead or behind? Or maybe if I ask our international organization representatives, if you could design a directive, right, that you wanted to give out to your members that would help harness these energies, how would you design it? Okay, those are sort of big questions, but thinking about the EO as a model, as something that could precipitate more of the same, where do we go with this? Sarah, can I throw to you first? An easy question.
Easy. No, I mean, I think a lot of it is building on the previous round a little bit again. You know, if we look at it from the international standard setting engagement environment, we need people to come on board and to be willing to invest time and effort into this standard setting work as a basis for regulation at the national level. So, I mean, whatever you can do at the national level that promotes that and that gives, I think, not just your negotiators, but also your experts, also your scientists, the freedom or the space to engage in that is going to benefit us. So we, in the standard setting we rely on scientific advice, which is led by FAO, but depends a lot also on experts from many countries. And many of them tell us, well, they require permission from their governments or from their organizations to participate in this international fora to do this. So if there's not something in the national context that encourages or allows that, I think we will all lose out. When one country, I think, shows leadership in that area, it also is very encouraging to others, because when there's some big players in, others want to be at the table as well. So I think from the international perspective, it's only positive to have something like this that provides encouragement to engage and also gives space for the experts to actually engage in these kind of initiatives. Thanks.
Thanks a lot, Sarah. James, I know you're working with your US colleagues all the time. How would you do this differently? What does the future of your cooperation look like? Where is the US behind, ahead?
I'm going to go a little more international and multilateral, and probably actually more into Sarah's world about, like, we are going to need, we can't all regulate and get out ahead and have domestic made solutions on everything. We are going to need to have trusted partners and say, from a resource perspective, you provide some leadership in this area, you provide some leadership in this area, you provide some leadership in this area, because we respecting sovereignty, and we will always need to respect domestic sovereignty. But at the same time, we can't be developing made at home solutions on everything. We are going to have to find a way to rely on those trusted partners and just say, we are going to, the Australia model, let's sleep on the Australia model and move forward on that. The New Zealand model, let's leap on that and move forward on that. They've put the resources in, they have a trusted solution, because I can't, so it comes to instrument choice, right? The first question we're supposed to ask is, do you need to regulate? And then the second question should be, does somebody else have leadership in this area, instead of coming up with our own domestic set of regulations? So it is that instrument choice as we move, as things become more, Dan's imperatives about like climate technology, like that's bang on. Those are the forward-thinking cooperation areas. But I'm not sure all of us have the horsepower to have domestic solutions in all of those.
Last thought, maybe like a wrap. I invite Dan you to comment on what James said, and then we'll give Mariana the last word.
And I'll stop if James resumes.
Yes, well, that's okay. Yeah, we lost you for a second, James, but I think we got just at the end of your point. And I'm now inviting Dan to comment on what you said. And do you agree with what James said?
Yeah. And I think more broadly, we need to have a broad public and international narrative that international regulatory cooperation is a way of achieving the highest level of protection that you want to achieve in your jurisdiction. You need to create a contesting narrative to the one that says cooperation means you're going to dilute your standards. Cooperation is like a secret deregulation agenda. Unless it's very clear and understood throughout the NGO community, the government community, the private sector stakeholder community, that this international regulatory cooperation is a way of creating efficiencies to better protect the consumer, you're always going to run up against headwinds because the cooperation with foreigners is always going to be regarded with some skepticism. So I think developing that education and that narrative, I think is critically important. And I'd also say that a lot of these current challenges that we're facing, the CBAM, the IRA, the various parts of industrial policy, the CHIPS Act, all these different things, these are all the forward-looking issues. The ones that James said are relatively easier to fix than, hormones and chlorine chicken and, God knows what all else. So, those should be the easier ones. And coincidentally, they also happen to be the most critical ones. But I think changing that narrative that somehow cooperation is a compromise to achieving regulatory objectives, unless you can fix that narrative, you're always going to be a little bit hobbled in the operation area.
Mariana, you're nodding, and I assume you agree with that. So I assume you will also give us the answer. How do we create that narrative?
I wish I knew that would solve a lot of problems for the OECD and for everyone. But I think, I couldn't agree more with what everyone has been saying. And I think a few ideas came to mind as others were speaking. One is that indeed there could be a better pooling of resources. Typically, really, if we go back to the fact that IRC is considered a kind of good regulatory practice, we could even think of sort of pooling of resources around impact assessments with transboundary impacts, really sharing across countries what the impacts on the environment are across borders, what the impacts on human health are across borders, etc., so that then the regulators use that regardless of where the studies come from. It is done sometimes, but a kind of better and more systematic approach with more centralized information about regulatory impacts could be useful on that to prioritize IRC. Another could be indeed a more systematic kind of risk-based approach to international regulatory cooperation, sort of along the lines of what's being said on the fact that if there really is a strong and very important human health rationale, then yes, the cooperation, there's strong incentive for cooperation, and it should not. And if the scientific evidence points towards that, then there should be less of an issue. And then if the questions are a bit more based on cultural and historic kind of circumstances, then there can be different approaches. And then finally, maybe just to finish with a bit of an interesting example of a project that we're currently working on that perhaps could give ideas on how to shape this narrative is that several speakers in the first session talked a lot about the ivory tower, and many of us, I mean, beyond, I'm not in academia anymore, but still, I mean, I can't say the OECD is not a bit of an ivory tower as well. We have a project which the EU Commission has been funding on actually doing a citizen survey to identify where the biggest burdens for citizens, administrative burdens are for citizens crossing the border. So basically people living in France and Germany, but very near the border, crossing the border for work, study, or health reasons every day or very, very frequently. What kind of administrative issues come up? And that citizen survey was conducted with more than 4,000 people and identified specific procedures where the biggest burdens are. And I think that's quite in my view, quite an interesting example of how really we're bringing the two very far away ends of the spectrum closer together, because we very often talk about regulatory cooperation as this high level political issue. We talked about it also as experts, many of us just as even in our everyday kind of policy work talk about it, but the actual impact for citizens is quite different and is not very tangible. So perhaps even going beyond businesses who maybe see regulatory cooperation a bit more easily, but they fuel more the discussion about trade barriers, and that can get into the narrative that Dan was mentioning. Perhaps a focus more on the benefits of regulatory cooperation for citizens could be an interesting approach.
Really important point to end on. Thanks, Mariana, for that, and bringing us back to the ground level for what we're all sort of here for in the first place. We have been so privileged to have all four of you with us. Thank you so much for your time. Our star-studded panel, I couldn't have asked for more. Please join me in thanking our panel. You all get on with your evenings overseas and rest of your afternoon. James, thank you and take good care. For those in the room, lunch is available to your left, and then we'll reconvene here at 12:45.
Okay, everyone, let's get started again. Hope everyone got a chance to get their lunch. Please go ahead and keep eating. That's part of the definition of fireside chat. We're joined once again by Professor Kathleen Lawson, who we know well now, and I am delighted to introduce joining her our second fireside chat speaker, our main fireside chat speaker, the Honorable Judge Timothy M. Reif of the United States Court of International Trade. It looks like many of you know him already. Judge, thank you so much for being here. I have to admit right off the bat, though, when I was preparing your introduction, I expected a much older man, given all that you've accomplished so far. So I'm even more impressed, and I look forward to what you can accomplish in the future. His prior work includes, before taking the bench, he was a senior advisor to the U.S. Trade Representative. And from 1998 to 2009, he was the Chief International Trade Counsel for the Ways and Means Committee of the United States House of Representatives, which he also served previously as Trade Counsel. Reif was the Special International Trade Counsel for the law firm of Dewey Ballantyne, and from 1989 to 1993. Reif was the Associate General Counsel in the Office of the U.S. Trade Representative. At Columbia Law School, Georgetown University Law Center, and the Princeton School of Public Policy and International Affairs. Judge, welcome to our forum. And as I told everyone, we're all pretending we're listening on radios.
Thank you so much, Chairman Fois, for that kind introduction. And on the part about being not as old as you'd expected, can we have that sent to my children?
Okay, Boomer.
I am, although I don't. Okay. I'm going to demonstrate to Kathleen why it's been 10 years since you last invited me. Why it's going to be another 10 years. Okay, so would you like to throw out?
I would like to throw out, thank you. But first, I just wanted to also thank you, Judge Reif, for making time to be here and add my welcome to Andy's. As some of you heard, I had the privilege of working with Judge Reif in the pre-judge days, again, back at USTR. Pretty much everything that I know about international regulatory cooperation and trade certainly comes from him and learning at USTR. He was so generous to hire me there. So we're going to, for our chat, we're going to sort of transport ourselves back in those days somewhat and sort of hear some stories from life on the front lines of international regulatory cooperation in those early years and when he was general counsel at USTR. So maybe, Judge, to kick off, what I would ask you is, well, maybe if I asked 10 people off the street before we came to our conversation, if I asked them about USTR and what does USTR contribute to international regulatory cooperation, I'm not sure many people who, having been general counsel, you were responsible for overseeing the legal aspects of our trade policy. And so tell us, if you would, how you see the role of USTR in the story that we're trying to tell.
I want to say first, the most expensive academic of the generation. I understand I'm not other potential candidates for that, but Kathleen is incredible, and so she focuses her attention on something. I learned and everybody else learned. This is one of those areas. So because Kathleen's written extensively on the subject of USTR's role and how it operates. And so I would say two things to the 10 people on the street about USTR's role. First, its role is to get the entire executive branch on a single page. Before talking to anybody outside the borders of the United States. And as Kathleen has written, USTR does that. It is one of its statutory mandates and responsibilities. Coordinates the trade policy. And that it does with mixed success in this area of, I would say, in the area of regulatory collaboration, cooperation. Because I was going to mention this in another context. What USTR sometimes has trouble, including my own self and then the office of people that I work. Trouble understanding is that it is very much an art, and it's very much a give and take to work with regulators who understand what they're doing. USTR, of course, doesn't understand very well what they're doing. To try to work with them to earn their trust and confidence so that a position can be developed. So that's step number one, and it's often said jokingly, but not really, that the United States government spends longer negotiating with itself than it does with those across the table. A good example of that, by the way, was the semiconductor agreement with Japan. It's the successor to the 1986 agreement with Japan. And having been a part of that, yes, I'm old, it took an enormous amount of effort to get a negotiating position, and then took the second piece of what USTR does is actually to work across the border. Here, the same pitfall occurred because the persons that USTR would be meeting with, the Commission or in Japan, it's METI or whichever government it might be, are not necessarily the keepers of the flame in their particular government. So there's the same pitfall there, but that is USTR's responsibility. And so the key is USTR to understand with a little bit of humility that I may not have always brought to past, or Margaret worked with me, I think, might not all have always brought that to the table. And it's a trick to get everybody on the same page and to negotiate an agreement, and also to do so with the right kind of humility.
Okay, well, with that sort of baseline understanding about how USTR fits into this story, because again, a lot of what we spent the morning on was thinking about OIRA in that story, right? And so trying to herd cats, right, whether on from the OIRA side or on the USTR side, maybe part of the story. But you've seen a lot in that capacity. So maybe if you would give us some examples or things that stand out in your mind from that experience in that work.
Okay, so I'm going to give, may I do the takeaways?
You may do, you have the floor.
So you can all tune out and check your email. I'm going to give you a 5-minute set of takeaways, and then we can talk about the examples. I thought I'd kind of put the each line at the top. First is that every episode is sui generis. This is the reason that Kathleen will never invite me to say it. And this obviously comes as big news. You're going to go shopping for regulatory convergence. Don't go to Macy's. You're going to have to go to about 30 different boutique stores, negotiate in every single one. There may be some slight relevance, very, and sadly didn't do some of the fascinating comments. And it's important to stop for a moment, listen to the context that you're in, or likely your goals are going to crack. So keep them sort of in the back of the mind before you bring them front of mind and out the mouth. 5, what I call, so beyond the sui generis. So what can I actually say that might be of the, I'm going to throw out 5 common denominators, all growing out of experiences that I had. First, guidelining regulators doesn't work. Guidelining regulators doesn't work. Now, that is a, Kathleen was saying, I got burned many different times with colleagues across the government. I will not name people, I won't name agencies. And whether it was my responsibility or not for that. But this reminds me of the scene in The Princess Bride, this wonderful Reiner movie. If you haven't seen it, please enjoy it. Margaret knows I always kind of think I always think. There's a wonderful scene where they have to go through the incredibly dangerous forest. It has things like fire pits, but my favorite in the forest is called rodents of unusual size. Now, if you've ever seen a capybara running around Brazil, about that big, it's a pretty big. These things are about 3 times the size of a capybara, and they have a really bad attitude.
That's supposed to be which agency then?
Right. So I'm not.
Capybara, not an
So
agency.
you cannot go around the forest. You cannot fly over the forest. You've got to go through the forest and find a way to work with people who, taking a line from the original Men in Black, feel that the regulations on which they have worked for a very substantial, if not most of their career, are the best of the best of the best. Also great to do that. I work with regulators, and they are typically convinced of what they find. Second, an effective OIRA, I take a lot about it. Howard Shalansky, who was like the food chain of it, incredibly able servants, attorneys. An effective OIRA is critical to U.S. government creating a space. And the reason that USTR sometimes clunks into OIRA is because the typical USTR attitude is, wait a second, I am the center of the table. I will work this all out, whereas it's actually the OIRA director that often does. When we talk about IUU fishing, that's an instance where his brilliance and the dynamics worked successfully in that space. Doesn't always. Third, the solution is in the details. Everyone always says the devil is in the details, but what I have found as an attorney over many, many years is that there is no problem, literally no problem, that cannot be ameliorated, if not fully solved, by digging into the details. The more you know about it, the more you get into it, the more you can find something to at least move the football 1 or 2 yards down the field if you can't throw them. Third, fourth. Contacts between regulators across borders is essential, but not sufficient. Necessary, but not sufficient to get the job done. So some of the examples we'll talk about, the regulators did know each other very well, but it didn't lead to a solution. They continue to have it. Finally, in a couple of parts, you got to know the landscape, and let me say what I mean by landscape. First, we're all operating on a landscape where global economic integration has slowed substantially, right? This is very, I'm sure none of you walking into the room thought this or knew this, but it is important to bear in mind, which means pick targets of opportunity more carefully. Look at where you think the bowling pins lined up. Second, the politics of an issue can be facilitating, and it can also be important to understand, and that doesn't mean only Congress, the executive branch, but also the next point, all the other players, private sector, which includes very importantly, when we talk about chemicals regulation or fishing, consumer groups, environmental groups, the Green Party in Europe. Next, I would say thinking about incentive structure. What are the headwinds or what are the tailwinds in the business community amongst regulatory entities? How much are you asking of another entity to do? In the IUU space, there wasn't a lot of cost to those. It was a big success in 2011, I guess, the original one. And then when the United States entered into a second regulatory phase that I was involved with, 2016, there wasn't a lot of cost to doing what we were doing and what we did with other parties. So think about the incentive structure. And finally, regulators, I would say, we're not in Kansas anymore. Now, with respect to Senator Dole, one of the great senators in America. What I mean by this is USTR had to learn this lesson. They still be working on it. And I don't mean to be pointing fingers at anybody there since I left. And what I remember as the moment where USTR had to leave Kansas was in 1989, walking out of the building. I saw on the lamppost a big poster on every single lamppost, like you have a parade, and it had 3 faceless bureaucrats atop a giant Godzilla with a dolphin dripping blood in its fangs. What had happened was the GATT had issued a ruling on U.S. regulations in areas where dolphins swim. And it was what became known as the tuna dolphin cases. And USTR at that moment had to actually wake up and understand that trade negotiations were no longer a very private, small matter that USTR could have conversations with different governments about. Everybody was looking in the window. There's going to be more looking in the window about every different kind of thing, consumer groups and everything else. And being a little bit audacious to say this, but I think that those who master areas of regulation, telecom, chemicals, or whatever they may be, may still have been a little bit behind in understanding. Maybe in this very space. So I look forward to hearing. I think are probably behind that shock that came to USTR in 1989, and which that building is probably still working to absorb fully. So those are my takeaways. Or anything else.
Well, there's a lot in there. Thanks so much, Judge. Let's go, if we could, to the IUU fishing story. You've mentioned it a couple of times, and maybe not everyone will be familiar with that story. What was at stake, and how that then precipitated the lessons that you mentioned. You mentioned particularly in that context the OIRA USTR relationship, and then to hear what you just said now about the posters, which are you know, painted quite an image for us, and I'm sure they were even more impactful to see up front. You know, one gets the impression that maybe USTR gets sort of the political flack, and maybe OIRA is playing some other role in the story. I'm curious to hear more about how you saw that dynamic, especially in the IUU fishing saga.
The first thing I would say is that, as you said at an OIRA table, important for everybody to understand there are people behind you. I mean, staff team, I was behind or in front, but the members of Congress, the groups that are supporting the position, there's a whole line of people, and so it's important to be in dialogue with the USTR, and you're dealing with an agency that very much wants to promulgate the strongest possible form of in this case, it was the second instance in which we were creating the regulations for a seafood management program that was to implement a congressional law. And so there was the dynamic of having that, and state and NOAA were out front seeking the most aggressive approach to that regulation. I wandered into the table representing USTR, thinking about, well, as we try to work out supply chain, which is the only way effectively to ensure that the system would work, to make sure that the fish that were coming into the process were in fact properly fished and didn't violate the regulations of the international agreement. We had a national treatment standard to follow, and which didn't allow us to ask as much about the importer as we were able to ask about our own fish farmers and fishing industry. And so USTR came in with a wait a second kind of perspective. Howard Schlansky, being Howard Schlansky, had a mandate from the administration, this is where President Obama wanted to go, to get this done. So was able to kind of nudge players, and happily state was represented by Kathy Novelli, who was Undersecretary for Economic Affairs in the latter part of the Obama administration. And Kathy happily had Dan Mulaney's job before him. So she understood USTR's perspective, and she also understood her agency, the State Department's perspective at that point in time. That really helped because, and also her general frame of mind is very bright and very sensitive to all perspectives. And there was able, therefore, to develop a dialogue that Howard encouraged that led to an agreement there. So when I said sui generis, having a Howard and knowing how, where he knew how to kind of use the pressure and use the non-pressure, just getting people together. Having Kathy in the room, who was able to be a useful conduit, enabled us to get, you've noticed that I haven't mentioned a lot about a participant who was really dug in And they might have said that USTR was dug in, but those dynamics enabled us to get through to an agreement. And by the way, Kathy, even though she hadn't been a lawyer, Kathy is a lawyer, but she hadn't been a lawyer at USTR, was really struck by what I was telling her about the nature of how national treatment was being interpreted by the appellate body of the WTO. She was in a kind of a holy cow. And after those conversations over a period of months, she was having bilateral meetings with others in other countries who were pressing us to do other kinds of things, or might have been concerned about the way we were applying our regulations, and was able to explain to them the constraints that we were all operating under and the WTO rules. But she didn't understand that coming in. So I don't like to say that everything can be resolved if people just understand a position better. But here actually there was an awakening, and I'm sure she explained many things to me, and Noah did as well.
That's an instance, it sounded like, where the mandate came from on high, right? Are there other instances, some of what we've been working through, I think, over the course of the mornings, we've been calling it sort of forward-looking, backward-looking, where, you know, an agency comes with an agenda, right? And maybe in some instances, USTR has to say, wait, that's a problem for us in Geneva. That's a problem for us under international trade law. There are other instances where the agency that has no agenda, but where USTR maybe is a partner in helping them drive toward a common standard. Is that a fair characterization of sort of USTR's role? Is one of them stronger than the other? How did you see that?
Well, the best counterpoint, I think, to the way IUU worked was where Treasury and the EU got together on the financial services agreement. And that was just two sets of regulators. There was no on high, there was no OIRA. There were two sets of very specialized regulators who found common ground because it was in their mutual interest in a very narrow area of insurance regulation. So in that space, you had the incentives lining up, private sector not particularly opposed, and it was very narrow circumstance. There haven't been any other types of regulations, and Dan Tarullo, who is one of the two who can talk both finance and trade, spent a lot of time looking at the dynamics of US and EU financial regulation. Here was one very narrow slice that the regulators just decided that they were going to move on, and were able to do that. And the private sector influence was fairly small, and it was coming in the wake of the financial crisis. So the Congress was supportive of it. Since 2009, 2010, those divisions that we normally see in Congress on this issue have returned, as you would normally see. So there was an opportunity where regulators, in a situation where the political landscape was supportive, could push through to get an agreement.
An agreement that was maybe under the radar?
Largely under the radar. And under the radar depends on how keen the radar. The radars were less keen at that moment, right? But the radars currently, that would not be under the radar, because the radars were restored to the radars were redirected towards the crisis that the United States was having, and of course other countries were having. So they weren't focused on this particular thing. It's like it's a patch of road where, I never do this, but it's a patch of road where the police aren't there and you can speed. In this case, you can just get through without the Congress pulling you over and saying, wait a second, what are you doing?
I'm sure none of us ever does that.
No.
Yeah, I mean, the under the radar thing is interesting, right? Because I think Ambassador Lighthizer, former USTR, made a comment before Congress a couple of years ago, where he sort of said, we do these one-fers and two-fers, right? And he was describing that as a way by which we achieve market access, right? That we are we're accomplishing goals for US producers, for US consumers, by doing these things. And maybe we don't need to tell everybody about it, and that's just fine. We're just doing it sort of off the radar or under the radar. But that also has consequences, right? When that happens. And you were also on the Hill, right? You've been all three branches of government. So I don't know if you want to say a little bit more about sort of where the Hill fits into this at all, or you know, whether transparency, how transparency cuts in the story.
transparency, having been the chief transparency officer of USTR, which was a role that basically I was privileged to have because nobody else in their right mind wanted it. And actually, I'm sometimes in my right mind, nor did I want it, but someone came to me and said, hey, I've got an offer that you can't refuse. No, but so the Congress is involved where they want to be involved. And so if you're lucky enough to have a landscape where political waters are quiet enough for you to be able to proceed through and get something done, then as Ambassador Lighthizer said, do it. And whether that's a perfect level of transparency, I know you've written a lot about this and have very carefully considered and thoughts that I always read and put into their papers. And it may not be an objectively good space, but it can be a space where things are cheap. I mean, the US-China accounting agreement is one where the agreement itself isn't even public. And yet the ability to brief to some extent by the administration to the Congress has worked. And that's an unusual circumstance to have in this day and age.
And how does that work? I mean, to tell us more about that agreement, if you would. I mean, this is something that governs accounting standards somehow, or is a services agreement? Because then how do the accountants know what to account for, so to speak, in our relationship with China?
Right. No. So the agreement was negotiated. This is another regulator to regulator negotiation. It was negotiated directly by our PCAOB to China's MOF and also to their Securities Regulatory Commission. And it was a circumstance where Congress had just passed a law. And so this was a way to implement the law. And Congress is passing the law actually strengthen US negotiators' hand to learn more about Chinese companies that were listing in the United States on the securities markets, and which you're probably asking why did China have an incentive to be involved? And that goes to macroeconomic factors, perhaps political factors. I'm not an expert on the CCP and on the internal workings in China, but there was a desire, obviously, to continue to be involved in the US market through their investments. And so they had an incentive to come to the table and agree to somewhat greater transparency and accountability there, with a caveat, which is that there is a certain amount of latitude and discretion built into the agreement. And when the Chinese government announced the agreement, this was, of course, highlighted. It was highlighted that it was very much of a mutual agreement. And it remains to be seen, since the agreement is only a year and a half old, how well it's going to function and whether that discretion becomes a giant hole that you can drive an airplane through.
Let's say airplane, that's a whole nother area of trade law we don't want to get into. I know our time is short, so I would like to ask you a little bit about the bilateral relationship with Canada, since we spent some time on it this morning, and was mentioned this morning that was the most ambitious shared regulatory agenda that we have. So, but I do want to see if there are there questions from folks, because okay, so let me get Jim's question in and then.
Just a comment about STR. You say sometimes have strong power, not. I think STR's participation in executive branch is very a function of the personality they had. And when Bob Strauss was there, let me tell you, if you got in an argument with USTR, you had a problem you'd never forget. And I was in a cabinet meeting one day, and President Carter's cousin or somebody was in charge of reducing our expenses. And one of the ideas he came up with was that no cabinet member could ride first class. And so he goes around the cabinet room and he says, Mr. Secretary, and everyone goes, yes, I'm fine. What's that? Consumer clothing. And then he comes to Strauss and he says, he looks at everyone and he talks to Bob and he says, everyone, Mr. President, is fine this way except one. And he doesn't say Bob Strauss. He looks at Strauss. Strauss looks up and says, is there a better way? So if you get a USTR guy like him, you have a lot of power. And he did. when you got it, when under President Carter, USTR was a strong place to deal with. And I was an OB, we don't generally genuflect too much, but that guy was pretty big.
Yeah, I think that's a very valid point. It varies from administration to administration, depending on the personality and the strength of the person who's there, how close they are to the president. I will flag that you and, for example, Mickey Cantor, who was very close to President Clinton. I will flag what to me has always stood out. First time I came to USTR in early 1989, Ambassador Hills had just been appointed. She was not close to President Bush. And in fact, his Commerce Secretary, Bob Mosbacher, was much closer. They were friends in Texas. And through the sheer force of her integrity and her intelligence and her work habits, she became the dominant president. So it isn't always that connections and personal relationships dominate. And she, by the way, knew nothing about trade. She'd been President Ford, Secretary of Housing and Urban Development. She was an antitrust lawyer. So she, like most antitrust lawyers, they think that trade lawyers do not have opposable thumbs. But she suppressed those instincts, became an incredible USTR. And one thing she did, I'll stop at, that I urge everyone to remember, is she hired the smartest people she could find. She was not insecure, as many CEOs or heads of agencies can be. She hired people who knew way more about the different things. She hired Josh Bolton to be her general counsel because he had come from Senator Packwood's staff and he understood the Senate better than anyone. He also understood myriad things. She hired Jules Katz, who's incredible. You'll remember Jules. This incredible State Department official who knew more about the Gap than any living human being at the time. Anyway, and that made her stronger. And she assembled a fantastic team. She was a very strong USTR in a very different way than Ambassador Strauss was.
Ambassador Strauss in the class always up.
Well, maybe we can wrap with just my last question about the Canadian relationship. Now, Canada, of course, we've got a number of long-standing disputes. We've got a number of success stories. What's your take on what's worked and hasn't worked with this Canada relationship?
Lumber's not worked so well.
Lumber.
Kathleen, I'm not an expert on the regulatory work that we've done with Canada. I don't want to, I'm a good enough lawyer not to try to say something when I'm out of my depth. So I don't know how that's working. My impression is there's some recent efforts that are very much conversational, where a person who specializes in results and dispute settlement and that kind of thing tends to think of conversation as critical, sort of the foothills of getting something done, but not the mountains the peaks that you want to be climbing. So that is probably not a fair, full response to your question, though.
That's a fine response. And we've already taken so much of your time. You have given us so much in this short time that we have had. I've got all your 5 points here, plus the movie references. We'll all now make sure we fulfill, get those movies seen. Thank you, Judge, so much for being so generous to spend your lunch with us. We'll break until 1:30.
Let's slow this down. That voice is kind of lost.
All right, everyone. We've been running right on time, so it's 1:30. So let's get started with our third panel. The moderator of which is Professor Elena Chachko, an assistant professor of law at Berkeley Law School. Equally accomplished given this early point in her career. She teaches at Berkeley. Before that, she was the inaugural Rappaport Fellow at Harvard Law School. Motivated by her own experience in diplomacy and intelligence analysis, Professor Chachko's research explores the intersection of law and geopolitics. Her recent projects study international cooperation in the administrative state, how agencies engage with international norms and practices, domestic regulation, the emergency governance of domestic and international institutions, the security and geopolitical aspects of tech governance, list here. These supposed to be specialties, Professor. National security and economic regulation and the rise of economic warfare in international relations. Professor Chachko's scholarship has been published or is forthcoming in distinguished legal publications. Her research has won several awards, including the 2020 Mike Lewis Prize for National Security Law Scholarship, the Harvard Law School Irving Oberman Writing Prize, and Harvard Law School's Mancini Prize. She's a member of the Berkeley Working Group on Emergency Technology Governance under the leadership of Secretary Janet Napolitano at the Berkeley Goldman School of Public Policy. I had the pleasure of working with Secretary Napolitano in the Clinton Justice Department. Great. Okay, she will introduce our other panel. Professor, thanks very much.
Thank you so much, Andy, for this introduction. And I want to start by thanking all of you who are still here at the stage of the day. To our panelists who are here in person, we are very grateful to you for taking the time out of what must be an incredibly packed schedule to be with us here and share your experience. And thank you to my collaborators on this project, David and Kathleen, and to our ACUS team over there for helping us put this day together. So the first conversation of the day focused on the background story of Executive Order 13609, where it came from, what the context was. The second conversation of the day focused on the view from the international environment. And this panel is where we solve all the problems. So today we are going to talk about, in this panel, we are going to talk about the future of international regulatory cooperation in the United States and consider some best practices based on the lessons learned from how the executive order has been implemented and how international regulatory cooperation has been conducted to date, to think about ways to improve it and to make it a more salient component of regulation in the government. So I would like to start by making a few introductory points about the context in which this conversation is being held today, and two factors that I suggest our panelists address and consider. The first is, from all of our conversations today, we hear many different approaches to what international regulatory cooperation actually is. So is it just about harmonizing international standards? Is it about making sure there are no unnecessary impediments to cross-border economic activity? Or is it something broader that also engages the various ways in which agencies interact with the international environment in their day-to-day work, from the implementation of international agreements through the incorporation of treaties into US domestic law through regulation, the incorporation of foreign policy interests in domestic regulation, so on and so forth. So one big question is, what is international regulatory cooperation and what is the scope of this phenomenon? And all of this are being addressed in our report that I will and the second sort of background comment has to do with the context. The judicial context, we all know that the Supreme Court is leading a doctrinal shift in administrative law that has resulted in restriction of agency discretion and the extent to which agencies may rely on statutes to advance new regulations. And this signals a broader sort of, suspicion toward the administrative state and perhaps how the courts might address future regulatory work by agencies. And the second issue that was touched upon in our first panels is downgrading of international regulatory cooperation, called is moving to a more applying something closer to industrial policies and to imposing and creating new rules and new policies that make it harder to advance international regulatory cooperation. So these are sort of two context observations in which any conversation about the future of international regulatory cooperation in the administrative state will have to take place. So our panelists today represent agencies and industry. And it is a pleasure to be able to hear from the people who are actually doing this work on a day-to-day basis and to see how you have experienced international regulatory cooperation in your own domains. We have with us Alex Exer from the Department of Transportation. Sean Heather is Senior Vice President, International Regulatory Affairs and Antitrust at the U.S. Chamber of Commerce. And Mary Brett Rogers Springs joins us from the State Department, where she is Director of Economic Policy at the Bureau of East Asia and Pacific Affairs. She has 25 years, if I'm not wrong, of experience as a Foreign Service officer with a broad range of geographic expertise, as well as specific specialization in economic affairs. So I thank all of you for being here today. I thought I would start by inviting each of you to share what international regulatory cooperation looks like in your day-to-day life, to explain a little bit more about your work, about your activities, about your responsibilities. So let me start with Alex.
Sure.
3 minutes.
So thank you for having me here. I really appreciate being able to contribute to such an important conversation. I'm an attorney in the Office of Regulation and Legislation in the Office of General Counsel in the Office of the Secretary of Transportation. For those of you who are not familiar with the Department of Transportation or DOT, we're a relatively decentralized agency. Think hub and spoke of a bicycle wheel, where we have 9 operating administrations, each one headed by a presidentially nominated Senate confirmed administrator, and each one dealing with roughly a single mode of transportation. The way regulations and rulemaking generally work in the department is each operating administration will develop and write the rule on its own by the secretary. At that point, for non-significant rules in this administration, once their administrator signs off, that's it as far as review goes, they go out. For significant rules, they go to the Office of Management and Budget, but before we go there, they take a stop in my office. So my portfolio is aviation, so I review significant rules issued or drafted by the Federal Aviation Administration. And that review focuses on a number of different things. Of interest would be international cooperation. We look at, is there an international standard on the rule that's at issue that we are reviewing? Should there be one? Does it make sense to pause the rulemaking while an international standard is developed, or does it make sense to go forward? So those are the things we look at. Then once we look at that issue and a host of other issues, and once the rule clears and is signed by the secretary, it then goes to the Office of Management and Budget, which then does interagency review, as far as which includes our colleagues at the State Department and USTR. And as far as that review goes, we are the representatives of the Department of Transportation. So if during interagency review, the State Department raises an issue, or OMB raises an issue, or USTR raises an issue, we represent the conversation to ensure that the right subject matter experts are engaged and to outcome of the rule go out.
Let me turn now to Mary Brett.
First of all, thank you for inviting me today. I am a Foreign Service officer. I'm also an attorney by training. I'm not here as an attorney, but I think part of the reason why I was asked to join this particular panel is because I'm also the alternate senior official to Asia Pacific Economic Cooperation for the US State Department. So that means that APEC, which is a big chunk of what my office covers, is really what I'm here to talk more about today. Through the APEC Forum, we work a lot on international regulatory cooperation across a really broad array of sectors, pretty much anything that has to do with economics. And we do consider APEC as one of the premier platforms for advancing economic policies in the Asia Pacific, because our overall goal is to promote a free, fair, and open trade and investment environment and think about how to advance inclusive and sustainable growth. And a big part of that is getting the economies that are members of APEC to think about how they can create an enabling environment that makes sense. So The significance of APEC with its 21 member economies, and we talk about member economies because Hong Kong and Taiwan are part of APEC. They account for nearly 40% of the global population and nearly half of global trade. So if you can get them talking about best practices and how to think about regulatory environments that are able to facilitate good business and attract business and investment, it's going to make a big difference. They're the source of about 1.7 trillion in investment for the United States, and they support employment for up to 2.3 million American workers. So clearly we have a domestic angle importance for our foreign policy here. They are the destination for about 60% of US good exports, which exceeded 1.3 trillion, and they are 7 of our 10 top trading partners. So APEC for the last 30 years has really taken on the leadership role in tackling the issues that affect domestic and international marketplaces. And I think that the characterization of it as serving as an incubator for ideas to help shape the global economic architecture is important, because I've only been with this office for a little less than a year. I joined last July, and I've seen it. I've seen the conversations and how they take place. I've seen the excitement when there's something that people can really think about. Oh, you know, medical devices are something that sounds a little dry, but when you really get down to it, they are very, very important on a number of levels, both for the companies that export them, but also for the economies that are bringing those devices into their economy to improve their medical services. And, you know, we have shown as the United States a really enduring commitment to APEC. We've hosted 3 times, most recently in 2023. So I joined in the middle of our host year. Our theme was creating a resilient and sustainable future for all. And we were able to leverage our APEC host year to collaborate with like-minded partners to strengthen the international economic system and showcase the importance of APEC in the region, not just for American prosperity, but more broadly. And a lot of our deliverables focused on international regulatory cooperation. For example, I brought my little storytelling novel, but we did put together this good regulatory practices blueprint. This is online. It was welcomed by the APEC economic leaders in November, and it really helps sort of like put together a menu of options for economies to look at and think about. And consider whether or not they're applicable within their economies. So again, part of the sharing of best practices and really trying to think through things. We've also, I mentioned that the type of IRC we do covers a broad array of sectors in the economic realm, and that's things like automobiles, chemicals, water, medical products I mentioned already, food safety, greenhouse gases, so things that touch on a lot of global issues like climate change. And we work really, really closely with the Office of Management and Budget, with USTR, with the Department of Transportation, with USDA, where the subject matter expertise really lies in these. Because while my team is there to sort of facilitate this, we support very robust technical cooperation. It's really bringing the subject matter experts together across the economies to have these conversations that's important for sharing best practices. And really, I think, investigating how to make these things work in practice. You know, how do you adopt them? What makes sense? How does this help us? It's also important, though, that we don't just bring together the government officials, but also civil society and other voices into the conversation, including international organizations. There's very robust long-term cooperation with the Organization for Economic Cooperation and Development. I'll probably talk a little bit more about that later. Let me pause.
All right, this administration often thinks of us last. But
No.
right.
Okay, the chiefs of mission from across the globe are the US ambassadors from across the globe, chiefs of missions, are coming into the State Department today. And I had my office had the privilege of drafting remarks for our Assistant Secretary for East Asian and Pacific Affairs. And one of the things that we were sure to include was talking about APEC, where in APEC, we have consistently reiterated that the private sector is really the secret sauce for making it happen. And, you know, just talking about how important it is to partner and listen to the private sector. So don't want to forget mentioning that, sorry. But I'll stop there, I talked too much already, and I look forward to having more conversation as we go through the afternoon.
Thank you so much, Mayor Brett, and it's a good segue to Sean.
Well, it's been a long day. I apologize, I was not here earlier, but I thought I would liven things up a little bit. So let me pass these around. Unfortunately, anybody on Zoom isn't going to have any touch and feel, but you guys please take a look at these, pass them around. At the end of the session, we'll see if anybody can get the answer. One of these is made for the US market, the other is made for the European Union. The question, there's three questions. What is the difference between the two devices? That's the first question. The second question is, which one is for the US market, which one's for the European market? And then the third question is, why does the difference matter? Okay, so mess along with those while we have our, we'll come back to it. When I don't bring my props with these things, give my examples of what regulatory cooperation looks like in our minds. Anybody take an airplane this morning to get here or yesterday? Anybody take an airplane last week?
I did.
Okay, when was the last time someone flew internationally? All right, every time you get an airplane line, post 9/11 or shortly thereafter, you see a sign that says what? How much liquid can you bring on board? Or
4 milligrams.
or 100 milliliters, right? We're not on the metric system. We aren't going to the metric system. That's regulatory cooperation. You got people getting on planes going around the world. You got folks bringing liquids on that in most of the world measure things in milliliters. We're doing it in ounces. Guess what? 3 ounces and 100 milliliters. I can hold up 2 vials. They are not the same. Anybody know which one's more? 100 milliliters is bigger than 3 ounces. But the regulators have decided for the purposes of whether or not liquid explosives can take down an airplane, and for the purposes of whether or not we want to have everybody standing in lines at airports trying to figure out whether or not their 3 ounces is down to 100 milliliters or vice versa, that we're going to call those things equivalent. Nowhere else in society is 100 milliliters equivalent to 3 ounces, but it is for travel purposes. That's regulatory cooperation. So Sean Heather, I'm with the U.S. Chamber of Commerce. In 2008, we founded the Center for Global Regulatory Cooperation. Why? Because coming out of World War II, the average tariff amongst industrialized nations was a little over 40%. And the global trading system has driven that down to the average tariff now between industrialized nations of being a little less than 2%. The ability to trade cross-border is not blocked by tariffs. And that's starting to change now, but it has not been the case. We're gonna have some sounds in the background. We'll keep this thing lively as we get to the other day. But what's the problem for people trading across borders? Is the difference in regulation. When you're a large Fortune 500 company, you can have multiple assembly lines, and you can produce for different markets, and you can find ways to comply with the different regulations that are out there. But you get to be a more small and medium-sized enterprise, and you want to go global, and you want to enter another market, you've got to figure out how to make sure your product complies with what's going on in that market. And so regulatory cooperation was happening before the EO came along. It's been happening since the EOs came along. The question is, has the EO done anything to advance the speed, pace, and quality of regulatory cooperation? And I think the answer to that is, I'm not sure it has. And I say that because I was one of 2 people who sat over lunch to come up with the idea, and worked with Cass Sunstein and Jeff Weiss. Prior, it was actually Michael Fitzpatrick and I over lunch who came up with the idea. Michael was Cass's deputy, worked with Jeff. But we've been at this and seen this through all kinds of lenses, in TPP, through regulatory forbearance provisions, to in the TTIP with the European Union, when we had this grand vision to create all regulations, simpatico between us and the European Union, to the start of the RCC, and the fact that the Canadians love it and want to do something with us, but we can't figure out a way to match their energy, to any number of other efforts. We were there for the solvency summit agreement that Tim mentioned in financial services. Most recently, we have the example of US-EU data flows. People may have heard of a guy named Schrems, who basically said data transfers to the United States were a problem, and was successful in getting a European court to stop data transfers to the United States. He's done it twice. We've had to put in place mechanisms to allow data to flow to the United States. So we've seen this in a lot of different contexts over the years, and it's happening. So there's no denial that it's happening. The question is, has this executive order really been the driver of that? Has it driven cultural changes? Do regulators think about the international dimension of the work that they're doing? They do so more today than ever before. I mean, one of the oldest regulatory cooperation arrangements, I believe, Alex, that I know of is in the aviation space between the United States and the EU. Set aside Boeing headlines today. Look at, there's a Venn diagram, I'm sure you've seen it, of standards in planes. That's another great show and tell. A Boeing plane is built to technical standards, some 50,000 different technical standards, most of which are written in US standard setting bodies. Some are written in international standard setting bodies. An Airbus plane is similarly has about 50,000 technical standards that it's built to, most of which are European standard setting bodies. There's been a long history of fights between the United States and the European Union over whose standards are better and whose standards should we rely on in regulation. And ultimately, what you're going to find out, the answer to what you're passing around is a standard story. And we decided, rather than making sure that Boeing builds all of its planes to all 50,000 standards in Europe and vice versa, there's a Venn diagram that shows a lot of shared standards, but there's a lot of different standards. And at the end of the day, the regulator said, we're not going to get in the business of trying to double check everybody's standards. But if the US says a plane is airworthy, we're going to accept it. And if the Europeans say the plane is airworthy, we're going to accept it, vice versa. So just like 100 milliliters and 3 ounces, you put them next to it, there's a difference. You might be able to find some difference between some of the standards that these planes are built to, but they're not different in a way that matters materially for air safety. And for that reason, they've been certified and recognized on either side of the Atlantic. So there's lots of great examples of regulatory cooperation. Again, it's been happening. It's going to continue to happen. The question is, how much has this EO driven that, and what could the EO do going forward if you had an administration who was interested in putting more capital and equity behind that agenda? I'll stop there.
Thank you so much, Sean, and thanks for the props. And I just want to use this as an opportunity. If anyone has power over the regulation of toys in this room, mom of toddlers, I ask you to please ban all toys that produce noise.
I will tell you this, the difference between the two has nothing to do with the audio. So as cute as it is, that is not the secret to my questions.
So, I want to ask each of you questions. Try to get at how EO 1369 has operated in day-to-day work, and for those of you who are working at the intersection of regulation and diplomacy, how that interagency process has been working. But Alex, let me start with you. So to what extent do you come across the executive order in your day-to-day regulatory work? Is it just a box checking exercise for you that you've put where in regulations you have the section where you specify whether or not you've complied with various regulatory requirements, right? And often you will see a reference to the executive order as part of that section. Is that all it is for you, or has it changed anything in how you work and how you plan for the creation of new regulations and how you engage your foreign counterparts? Any information you can provide on that would be incredibly useful.
Sure. So aviation is a little bit different in that before the executive order, just by the nature of aviation, we had a significant amount of international coordination. The reason for it is, like Sean alluded to, an aircraft made in Europe is going to have to fly to the United States and vice versa. So it can't be that we just sit in our own little bubble and do our own thing and we don't affect each other. So in anticipation of that, at the dawn of aviation in the 1940s, a treaty was passed commonly called the Chicago Convention, which at this point has been signed and ratified by almost all of the UN member countries, including the United States. And what that treaty did is created an organization that's an agency of the United Nations called the International Civil Aviation Organization, or ICAO for short. And the way the treaty operates is ICAO can set standards for aviation, which most of these standards encompass very close to 90-95% of aviation. And the way they work is some of those are mandatory on the United States. So for example, standards that ICAO sets for what it calls the high seas, which is international waters, those are binding on the United States. So FAA is legally required by treaty to IBR those regulations unchanged. Most other standards set by ICAO, though, are not binding. We can implement partially, completely, or not at all. The only legal requirement is if we don't implement them fully, the United States has to honor what's called a difference of ICAO, explaining are between what ACUS has promulgated and what the United States has finalized. So how does this work in practice? Well, in practice, it means that when we are reviewing a rule that FAA has done, we have to consider, okay, does ACUS have a standard here? Which the answer is usually yes. And then does this rule meet the standard? And if not, is there a reason for it? And sometimes you can have a good reason, either a statutory constraint or even a policy disagreement. For example, I don't know if you remember, but back in the mid-2010s, there was a crash in Germany by a German pilot who had a mental health issue and brought down the plane. And at that point, you saw investigative news reports. One of the points they made that was a highlight for the United States is the United States historically has had higher mental health requirements checks for pilots seeking certification than the international community required. Sometimes it is an issue of, well, the international floor is here, we want to be up here, we want to be higher. So for policy differences, that is acceptable under a treaty. We just have to notify ACUS of advance what we have done. Separately, so as far as how the executive order changes, which I've talked about ACUS, but we did look at our process where we do want to coordinate, because whether or not we ultimately issue the same standard as another international organization or another government, we want to be aware of what standard they're issuing, because that is a data point we want to know. We don't want to differ with someone just because we don't know what they're doing. That doesn't make a lot of sense. So what we realized when we looked at the process for rulemaking in DOT, which my office manages, was that we had a policy that was inhibiting international cooperation, and that was our ex parte policy. For those unfamiliar, for the Department of Transportation, historically, we've had an ex parte policy that was very restrictive. It applied to communications with anyone outside the executive branch of a US government. So that's Congress, foreign governments, anyone not a member of the executive branch. And what it did is in certain parts of our rulemaking process, it prohibited or strongly discouraged all outside contacts outside the formal rulemaking notice and comment. So let's say you have an international issue where there's international equities and the United States is doing something, the international community is doing something. And at some point, under our old policy, when you get to the final rule stage, the United States can no longer talk to partners to see, hey, which way are you going with this? So you could ultimately get a result where a final rule is different from the international community simply because of a failure to communicate. So when we realized this was an issue after the executive order was issued, we took a look at it and said, okay, how can we ease up on that restriction to encourage more cooperation while at the same time maintaining the integrity of the rulemaking process and the transparency that was the driver for the whole policy. So we issued several iterations of updates, the most recent of which was in 2022, where now you can communicate to stakeholders, including international partners, as long as it's done in a transparent way. So you can communicate, but at the NPRM stage, you have to summarize the communication in NPRM. At the final rule stage, you have to post something to the docket. If you get something that you are relying on, that you want to, that's new, that you want to change a final rule, you might need to reopen the comment period. So this allowed for more cooperation as a result of the executive order about the same time.
And one related question is, do you feel you have sufficient authorities under existing statutory regimes that govern your operations, executive orders, and any other sorts of authority to do what you need to do on the international plane?
So we do to an extent. There's no statute that says you cannot talk to foreign governments. We want to coordinate. We don't want to have a difference with another foreign government or international agency just because we're not talking to them. At the same time, because of how our administrative process works, there are limits to that communication. So for example, the APA and the surrounding case law prohibits us from prejudging our rulemaking. What that means is at the beginning of a rulemaking process, I cannot tell you what the final rule is going to say, or even if there will be a final rule, because as an agency official, I have to be open to the possibility that I will get a comment that makes me change the direction my rule is going in, or even convinces me that a final rule is unnecessary, or that we should do something different than the rulemaking altogether. So because of that, if we're talking to our foreign counterparts and a rulemaking has not yet begun, we cannot make any commitments that, hey, we're going to issue a final rule on this and this date, and it's going to do X, Y, and Z, because we have not yet seen the comments, and we have to remain open to the possibility that those comments will change your mind about what we're doing. And that can be very frustrating for foreign partners who have different administrative procedure schemes, who don't have the same restrictions, who can make those commitments, where we are not being coy, we genuinely legally do not know what our final rule is going to say.
Thank you very much, Alex. And let me now turn to Mary Brett to talk a little bit more about the diplomatic side of things and the interface between the diplomatic side and the regulatory side. So my first question to you is, tell us a little bit more about the nature of your exchanges with your APAC partners and fellow diplomats. Are those exchanges mostly around best practices in regulation, or are they about specific substance, subject matter, and about the content of rules that various jurisdictions are expected to advance?
So APAC focuses on both regulatory best practices and the regulatory substance. One of the main goals, as I said before, of APAC is to share best practices among the participating economies, but we also implement capacity building programs. And we often work directly with economies, developing economies, let me be specific about that. So foreign assistance has rules on it too, to set and implement new standards. So, you know, the APEC for some of you may be characterized by every November, there's an economic leaders week, and the leaders come up with often a statement that sort of sets out sort of the broad goals and parameters. But over the course of any given APEC year, there are also hundreds of meetings. And a lot of those are among working groups that meet to discuss regulatory practices and exchange information. So I feel like that's really more the bread and butter of what we do in terms of trying to share information, but also work through questions, work through issues, put subject matters in contact with each other, build networks. And so some of the examples are, there's a subcommittee on standards and conformance, and it was really set up to reduce the negative impacts that can come with regulatory rulemaking, different standards that regulations have on trade flows. So trying to increase efficiency, not necessarily harmonization. I think it's more to say, is this having an impact? Does it create a barrier, and how would that be addressed? There's also the Competition Policy and Law Group, which shares information on developments in competition laws and policy among the APEC economies and identifies best practices. The Economic Committee of APEC promotes structural reform in the economies, and the goal is to support, again, the sustainable and inclusive economic growth. This includes the promotion of regulatory practices throughout APEC, and is often done in combination with the subcommittee on standards and conformance. So, I mean, you're kind of working back and forth in some ways between the two. We have a fairly robust capacity building program, and we try to, when an economy or when something is proposed where there's been an agreement at a high level that we want to look at a certain aspect of something, we try to design our technical capacity building to really have an impact and to address the needs of the economies and look these issues, both from is information important, or also like what I don't know if nuts and bolts is quite the right way to put it, but you know, what would be needed to be done to implement new standards and regulations. So working back and forth between the two.
Great. And so if we look at the interagency, what happens on the back end or after you negotiate something at the APEC level and try to bring it home. How does the process work? How do you bring in the various experts from the regulatory agencies? What does the consultation look like? What are some of the obstacles that you've encountered? Is there a particular example where things worked well or didn't work at all that you can share with us?
So I can talk about, like, I just came back. You asked if I've been on an international flight. I just came back from Peru. Peru is hosting APEC this year, and they have a number of priorities in their APEC host year. But in the second cluster of senior officials meetings that was held in Arequipa in Peru, there were several ministerial level meetings. There were the ministers responsible for trade and the ministers responsible for women. And there were 3 consensus statements that came out of the MRT, the WEF, the Women's Economic Forum, and the joint ministerial that they held for women in trade. The negotiations for those consensus documents involve input from the interagency. And so that's the high level commitment among APEC, which is a consensus non-binding organization. But once you have that consensus at the high level, the working groups that I'm talking about are some of the ways that you help economies meet those agreed to, high level political commitments that come about in those documents. So the interagency process and the White House are very involved in sort of sometimes setting some of the things that we can and cannot do within those documents. We don't want to create a situation where we have a high level political commitment to something that's contrary to our laws or contrary to where our political position is on something. And it can be difficult. I mean, these are 21 very different economies. Russia and China are part of APEC, and there are geopolitical dynamics in APEC. Russia's invasion of Ukraine created, a lot of economic impact across commodities markets in energy and food prices and food security. And so there have been some challenges over the past couple of years, especially related to that. The situation in Gaza has caused some consternation. We try to keep as much of that as possible separate from APEC, which is an economic organization, but sometimes there are economic impacts. So once you have a consensus among the ministers, which feeds into the leaders meeting that I spoke about, you really have to look at how are we going to do this. And this is where those bringing the subject matter experts in and the folks that really understand where our lines are is really, really important. And we, again, my office works a lot on the institutionality of APEC and structure. Bringing the right stakeholders into the conversation is part of what we work very, very hard to do. And it depends on the group as to how that works. So I hope that kind of addresses.
And maybe one more follow-up question on the working groups. So Alex and others have mentioned the regulatory working group that was established by the executive order to sort of see through and oversee the implementation of the executive order. Alex, if you can share anything about any experience you might have had with the regulatory working group, and how do these working groups that you create ad hoc around various APEC activities interface with that working group, if they interface, or are those just islands that operate separately within the government?
I think I might not necessarily fully agree with the islands that operate separately. I think part of the reason for bringing in the specific subject matter experts from different agencies, whether it be the U.S. Trade Representative or the Office of Management and Budget or Transportation or USDA, Commerce, anywhere else, is because they are more closely allied with that and can kind of understand better maybe what the contours are of it than my office does from our more from a higher sort of perspective. So I see a lot of incredibly conscientious people. We just did a whole series, there's some folks in the room who might know this, we did a whole series of sort of just checking in with some of the different agencies to make sure that we were thinking about what's happening in APEC and understood, constantly touching base to understand whether there are things that we do need to be thinking about more broadly. But it's hard for me to draw that direct line for you because there's a number of people who know more about it than my office might.
Yeah, that's helpful. Alex?
And I would agree with that. There's no set line. For example, we have a rule, a significant rule that goes through us and goes to OMB. Well, OMB sits on the working group. So any discussion, any conversation that has in the working group filters in through OMB review for that rule. So there's no, as far as process goes, there's no step where a rule goes to a working group. It just goes through people who participate in the working group and are informed of those conversations. And that feedback makes it to a rule that way.
Perfect. Thank you. I know everyone is dying to know the solution to Sean's or riddle, as it were. So Sean?
I'm happy to provide that now, I guess. All right, so question one was, what's the difference? What's the difference? Who's got the answer? Yes, what's the difference?
Key parts at the bottom, soft part.
Anybody else notice that? That's the answer. So these keys are rigid, okay? Called keys, they're rigid. These keys here are flexible. Okay, that's the difference. Which one's for the US market? Which one's for the European market? Give you the first
The
guess.
rigid one is for the US market. That's what I was gonna say.
Rigid for the US market. That is correct. Now, why is there the difference?
Something about choking hazard.
I don't
No,
have kids, I mean, Elena's probably spot on.
no,
Teething,
no.
orthodontics.
No. No, I would suspect this one would be better for a teething child than this one, but no. People typically go, well, obviously you have to have different set of chemicals to make soft plastic versus hard plastic, so maybe it's a chemical regulation difference. Nope, that's not it either. Do you know what these are? I would hand you one of these at a baby shower. What did I give you? Gave you a
Rattle.
yes. Okay, they're rattles. You hear that? Hear that? Okay. This rattle is kind of pathetic. This rattle rattles. There is a regulation as to how much noise a baby rattle can make in terms of decibels in the EU. And why is that? Apparently, if we're talking about like infants, right, who like to move and don't have control over their movements and are figuring all that out. Apparently, if you hold this up to your ear for 2.5 hours, 3 hours, and your arm doesn't get tired and you can hold it right up next to your ear, an infant may have hearing loss. But in practical effect, no infant has the motor skills or the arm strength to hold it up next to their eardrum. The length of time required that would result in hearing loss. Yet you have to manufacture two products. So that's the difference. There are in a democracy, a legislative process where people can make decisions that say, you know what, as a society, we're going to value our children not having hearing loss. Clearly, the United States doesn't care if your children have hearing. But this wasn't a decision that came out of a parliamentary structure. This was out of the bureaucracy of regulators who are self-empowered to make some of these calls and decisions. And you make it very difficult for them to justify this difference. But that's the difference. And that's the reason why Mattel makes one. You could argue, why don't they just make them both for the European market and sell it here? Probably because if you buy a baby rattle, you want to hear it, rattle.
Oh, you wouldn't.
But that's why it's a gift to the parent. The parent doesn't ever buy the baby rattle. It's always somebody who gives you the baby rattle. But that's the difference between the two. Well done for spotting the keys, and well done for then guessing which one was which. But it has to do with the decibel level of a baby's eardrum.
So Sean, that was a terrific illustration. And I want to try to generalize from that and think about how would you, as someone who is in industry, represents industry in this process, how would you think about categorizing instances in which international regulatory cooperation is a net positive for industries as opposed to when it is a net negative?
So I think, first of all, you have to subscribe to the view that regulatory cooperation is not about deregulation, but it is also not about pro-regulation. It starts from a position that, there's a regulatory given, and then how do you make that regulatory given work in a way that creates the least trade friction across border. And sometimes we have seen regulators advance the idea of advancing a pro-regulatory agenda in the name of regulatory cooperation. And sometimes you can see industry advance regulatory cooperation with a deregulatory agenda. When either of those things happen, you're not talking about regulatory cooperation, at least as I recognize it and define it. Certainly, the U.S. Chamber spends a lot of time, other parts of my organization, combating the administrative state and the regulatory overreach and so on and so forth, but that's not what regulatory cooperation is about. This is a very kind of finite, specific series of questions that you ask about given a regulatory given. In my mind, the ex ante approach. People talk all the time about should we do regulatory cooperation ex ante or ex post. And a lot of the agendas that have been tried to be built in the context of the RCC with Canada or TTIP, they fail around trying to figure out the ex post stuff, things that where regulations are already on the books and they're creating a trade friction. How do you figure out to build a bridge across those two things? Well, the regulators are too invested in their own regulatory schemes. They're too bought in. They don't want to spend the time. So people say, well, let's go talk about regulations in the future. Let's talk about ex ante. Well, inevitably going down the ex ante path means that you're talking about the need to regulate. And it's not always clear that everybody's on the same page with the need to regulate, regardless of Republican or Democrat. Historically, the United States has been slow to regulate. They look for market failure. Certainly, there are differences between the political parties on that. But generally, when you look at that versus outside the rest of the world, we're a common law jurisdiction versus civil law jurisdiction. Civil law jurisdictions, they want to write a law for everything. Who's really good at regulatory cooperation? The European Union. Their entire existence is a giant exercise in regulatory cooperation. They have 27 or 8, whatever member states they are up to after the UK left, and we're down to, not up to, and they are trying to take sovereign nations and put them under one commercial market. That there is no higher exercise in regulatory cooperation than that. You might argue our Commerce Clause in the Constitution is our version of that. We can debate and discuss that, but once they come up with a regulatory scheme, they are designed by their system to be out there and regulate first. They're very good about then going around the world to advance their commercial interests of their companies and telling other countries, we've figured this out, you should adopt our regulatory approach. That is not in the mandate of DOT. That is not in the mandate of US regulatory agencies to go out and promulgate or advance or promote the US regulatory approach. That's not a core function of any of these agencies. But it is in the European Union and how they operate. As a result, watch what happened with GDPR. Okay, GDPR was the privacy regulation in Europe. Some countries have now adopted GDPR with some tweaks. This administration, our administration at the time, did not support GDPR and went around the world suggesting there were alternatives to how you regulate privacy, but we didn't have an example. Regulate privacy for financial services, we regulate privacy for health, we do it on a sector basis, but we don't have a general data regulation. And of course, the business community probably wasn't going to be excited about passing a general law in the United States just so that we could have our regulators, even if they thought it was their mandate, running around the world, saying, well, look, don't take the European GDPR, take our approach. So, when you start having these conversations that regulatory cooperation is either there to advance a regulatory agenda, i.e., pro-regulatory approach to something, or on the other side, let's do this in a way that deregulates, then you're probably in territory where the exercise is not going to work real well. And that's, I think, what is the challenge, is to try to find those sweet spots. And it starts with good regulatory practices, which is the work that was being mentioned before, because if these countries around the world are kind of formalizing their regulatory rulemaking processes, they're bringing transparency, they're inviting stakeholders, they're scrutinizing their regulatory decision, there's at least a fighting chance that the outcome from that regulatory process will produce a regulation that is less trade restrictive, less of a trade irritant, more likely to be in a position that it could potentially be crosswalked with the regulatory outcome in another country where you've gone through a professionalized regulatory process. So when you look at this stuff, a lot of the pitfalls typically have you falling into those kind of we want to regulate camps or we want to deregulate camps, and that oftentimes prohibits the ability to get successful outcomes.
Thank you very much, Sean. So we have about 10 minutes left before I'd like to open the floor up to questions from the audience. And I thought we would take up the mission of this last panel head on, which is to dream about a potential future where perhaps a new instrument is promulgated on international regulatory cooperation, or more is done at the White House level to advance it than it's being done right now. What would be your wish list? What would be your dream? Alex, for instance, what happens to you every week that you say, oh man, I wish there was an executive order I could point to help me out here? So thinking about what a potential follow-up on EO 13609 might look like, what is on your wish list?
So honestly, for us, because I know that's not a satisfying answer, but we really thought hard about this one. Because our friction points as an agency are differences that Sean just alluded to, which is the US rulemaking process is designed to encourage deliberation, that we identify a problem, we identify potential solutions to it, which could be more than one, and then we proceed to take notice and comment, and then ultimately select or not select one of those solutions. Other countries do it differently. And there's trade-offs where deliberation means, you sacrifice, you trade off time while you are deliberating. You trade off certainty where someone from another country that can move faster could say, okay, I'm going to issue a final rule that does X, Y, and Z on this date. We can't do that. But those are all trade-offs, and those are good trade-offs to have where Congress has made that decision. And I think if you look at everything, not just international cooperation, but all the things that our current rulemaking process encourages, it ultimately is a good process.
Actually, it is a satisfying answer, believe it or not. Mary Brett.
I'm gonna hold my little guide here again, because this is not prescriptive. This is meant to be something where you go through some of the core elements and you do a cost benefit analysis. And I think deliberative is a great way to describe it. You sort of go through that analysis and trying to look at how you get through sort of the regulatory life cycle so that you can get to something that is not excessively restrictive. In the context of APEC, every economy is dealing with its own separate realities. We don't like to overly emphasize that. We like to sort of focus in on the things that can be moved forward and not look at all the obstacles. But again, referring back to CD cooperation, I think, bringing in these best practices, bringing in these conversations to say what works and what doesn't work. And I wanted to mention one other thing is that sometimes you do get to the point where you mentioned the plane regulations. Going back about 20 years, one of APEC's significant achievements is the 1999 Mutual Recognition Agreement for Telecom Equipment Testing, which basically says that if a telecom device is tested in one economy and it has the results accepted in other economies to try and reduce the costs and speed up product delivery. So when you can have things like that happen and you do get that sort of, it's that acceptance. It's basically saying this is okay for us too, even if it looks a little bit different, even if it is 3 ounces don't quite equal 100 milliliters, but we can work with this to help sort of promote trade and investment. I think that's really helpful. I wish I understood, and I apologize for not understanding a little bit better how the EO works that way, but I think that in our case, it's pretty permissive. Yeah. Going back to the actual agencies that have to implement it, that's what we look to. And I have not, nobody has said to me, oh, that EO is really, can't work with that. So I'm gonna take that as for us, it's working okay at the moment.
So I think the EO is intended to be an instrument to change the culture and mindset of the regulatory process in the United States. And that is happening over time. As I suggested, this stuff was happening before the EO came along. It would happen there. There have been certain events that have been accelerators. Financial crisis, accelerated regulatory cooperation. If anybody's ever read the book, Too Good to Fail, there's a chapter in there about the weekend Lehman Brothers went down. It's a regulatory cooperation story. We were trying to find a way to not have a government bailout after Bear Stearns. They pulled all the banks together in New York in for the weekend. They locked them all in a room and said, we need you to come up with $50 billion of your own money to bail out Lehman Brothers. They had locked away Barclays, and they had another locked away Bank of America. And they said, each of you are going to bid for how much you're going to pay for Lehman Brothers' good assets. So they would float the good assets money in with the money from the rest of the private sector to create a slush fund to deal with the bad assets that were there. Saturday night, Bank of America comes to Tim Geithner, who at the time was the head of the New York Fed, and says, we're not going to buy. Tim says, I don't care, you got to stay in the room. So we get Barclays to bid their price up higher. Sunday morning, they figured it out. We're going to have $50 billion from the rest of the banks to float the bad assets. Barclays, I think, had agreed to spend $5 or $6 billion, and Barclays negotiating canceled. There's only one problem. The problem was, well, in the UK, this is a merger and acquisition since we're acquiring Lehman Brothers. It requires a shareholder vote. And Tim Geithner says, what do you mean? We've been working on this for a week. You're telling me now Asian markets are going to open at 3 o'clock this afternoon on Sunday? You're telling me we got to go share? Well, we think that the UK regulator might waive this. So they had Chris Cox, who's chairman of the Security and Exchange Commission at the time, call over the UK regulator and say, hey, we got this great idea. We got this plan. Can you waive this fundamental shareholder right in your law? The UK regulator says, excuse me? There's a financial crisis that the entire world's about ready to get taken down on, and I'm going to trust that you've been working in a room and you've carved out the cancerous elements from your banking system into one pile and the good pieces in the other, and you're not going to import that cancer into my banking system in the UK? Are you flicking crazy? Yeah, 3 o'clock, Geithner called Lehman Brothers board, says we have no bailout, no rescue. We ended up flushing $2.5 trillion out of the global economy because nobody thought that Barclays had a different regulator. They should be in the conversation sooner. So events like that have a tendency to change the mindset of regulators overnight. And it has a tendency to make a much bigger evolution in the kind of cultural mindset of regulators than an executive order. How do you bring the executive order to life? It's not so much what's written in it, it's who's there pushing it and executing it. And it's a question of resources. Alex Hunt has left. There is nobody in OIRA, enough staff, spending their time thinking about regulatory cooperation, thinking about whether or not US agencies could be doing things different, doing things better. They do the best they can with the limited resources they have. But I would actually say a few more bucks to put some people in the chair inside of OMB to think about this. Typically, when OIRA travels for regulatory cooperation, they don't have the budget for a plane ticket. They got to go borrow it from State Department or somebody else.
We have an MOU to do that
so,
just for that reason.
You know, you can move the pieces around on the table of the executive order, but it's really a change element for culture. That change is happening. Supply chains over the last 20 years have been incredibly long. Get most of our seafood from foreign markets. So if you're the Food and Drug Administration, you better have some regulatory arrangements with where they're growing the seafood or catching it and bringing it into the food chain. So there are awakening that's happening, but in order to kind of coordinate that, marshal it, accelerate it, find other places where there's pinch points that could be done, I would argue that resources are probably the most important thing.
So if I try to summarize, Alex is happy, Mary Brad is not happy, and Sean thinks we need either more money or another financial crisis. Okay, thank you panelists so much. I would like to use our remaining time to open the floor up for questions from the audience here in the room and online. Kaja, Jeremy, let me know if anyone chimes in. Any questions from the audience? Comments, thoughts?
Okay, I'll ask 2 questions, one of which is really narrow. Mutual recognition over harmonization. Do you guys have thoughts on which is better, or you've talked about mutual recognition? It sounds like you guys have done that too, but is there some, no, you're doing a sort of harmonization thing through ICAO, right? Or, what are the pluses and minuses of either? And then the really narrow question is, one of the things that the executive order does is have people check a box if their rule is going to have international impact. I'm sort of wondering what the constituency is for that. So I get the idea that what we all want to do is create cooperation and common rules across borders. Why have American regulators make a special note that we're regulating as something that's going to work internationally?
So I'll answer harmonization versus recognition, and I think it's context specific. So harmonization works well in areas where you have a common operating environment. So for example, the reason in the original Chicago Convention that ICAO standards are binding on overseas is every country flies over high seas. So you can't have one US standard, one German standard, one another country standard. We're all using the same airspace. It has to be one requirement. So that's an area where I think harmonization makes most sense. Recognition makes sense where you have different standards, but you also want to acknowledge what each other is doing. So for example, and this is an example shown earlier, Airbus versus Boeing. So Airbus is manufactured in Europe, Boeing in the United States. But airworthiness, the actual certificate that allows the airplane to fly is actually issued by the country that the airline using the aircraft is registered in. So if a US airline buys an Airbus, it needs an FAA certificate, not a European one, and vice versa. And the way both systems work is through recognition, where a lot of the regulations, the substantive airworthiness regulations are the same, but there are differences. So what happens is when a US airline brings in an Airbus, the FAA will take the European agency's word that in the areas where the regulations are similar, they've done their work, that's done. So they will limit their review to only areas where US regulations impose a higher standard than European regulations. So in that context, harmonization would not work necessarily the same way because you have different countries with different needs, different operating environments. Even, for example, we're unique as far as Alaska goes, where some of our regulations are designed for an area where airplanes are an exclusive mode of transportation. There's no roads in parts of Alaska. Europe may not have those. So that's where harmonization may not make sense in certain areas, but at the same time, you still have other countries doing work, and that work doesn't need to be duplicated. That would be overkill.
Any other thoughts on this?
I'd just say, harmonization is rarely the option that works. Let's have its application, but the application for a mutual recognition arrangement is much broader because you're recognizing the regulatory outcome that shares in common, not so much how you get there. And harmonization required you to adopt the same regulation, and sometimes that works for floors, as you said in the case of the international treaty for aviation. But the U.S. has moved above the floor, for example, in the mental health requirement for pilots, and so you just notify it and say, look, if you want to be a pilot in the U.S. system, you're going to have to go above and beyond this floor for that aspect of it. So I don't use the word harmonization. It's a four-letter word in my vocabulary in this space because I think it brings with it a lot of baggage, and each side thinks that's who you're harmonizing to. You're harmonizing to my side, not me to yours. And convergences, we're going to take our regulations and somehow make them each less good and come to somewhere in the middle. That's not really a good vocabulary word. And then your second question was,
why check? Why have agencies check when they're doing?
So
I don't get with the constituency for that, really.
So that actually predates the executive order. Susan Dudley did that when she was the administrator of OIRA. Another suggestion from yours truly. The idea was that oftentimes regulatory agencies and our trading partners are not aware of what's happening in regulatory agencies. And so it's an opportunity for our trading partners from countries and other companies in other countries to more easily understand regulatory changes that might have impact that they supply into that process. And the hope was that other countries would adopt it as well. What I don't know is how well it's being monitored. My sense is that regulators are just checking that box for everything. And therefore, it's not really a sophisticated tool as it was originally intended to be. And there probably could be some analysis done on that. In trade parlance, there's things like TBT law, technical barrier to trade, and SPS related matters too, where you're supposed to build your regulations to be at least trade restrictive. And there's been lots of instances over the years where that's not necessarily been the case. And sometimes it's not because we're trying to create a trader intent or be industrial policy in our motivation for our regulation, but that could be the end result of basically just not recognizing products that are coming into the United States that are being used that would somehow no longer be able to comply. And so it's to take the blind spots out, essentially, was the original thinking.
Kathleen, you had your hand up.
Yeah, sure. if I may, small question for each of you. Maybe for Sean, the question is, if you added all those staff at OIRA, walk us through how you see what their job responsibilities would be, if you would. So that's one thing I'd like to hear more about. Second, for Mary Brett, I guess you kind of alluded to this, but maybe could you say a little bit more about APEC's intersections with other Asia Pacific initiatives, and when they clash, when they don't? Is there a point at which APEC tops out essentially, and now we have to do things through other means like trade agreements, for example, or other sorts of deals? So curious to hear about APEC's relationship with other economic alliances, so to speak, in the region. And for Alex, you talked about the sort of Chicago Convention baseline from which a lot of this seems to flow in aircraft. Is it a similar story, or what are some of the differences in the areas, in the other parts of DOT, the other sectors that are not aircraft? I know it's not your space, but if you could comment on some of those salient differences, that would be interesting.
Alex, you want to begin?
Sure. So again, not my area of expertise. My area of expertise is aviation, but for other operating administrations, you don't have the same kind of component of aviation. Because surface transportation, obviously we're not going to drive a car from here to Europe. Honestly, I'm going to have to punt on that one because that just to take a cue from an earlier panelist, I'm not going to issue. I'm not an expert on.
Wise. I'm not USTR, so I'm not going to talk about trade agreements because that is not my area. I will say that there, the APEC platform, APEC as a forum, often serves as a convening mechanism, but it also, again, serves as sort of a broader platform overall. If you have the leaders from 21 economies coming together, it creates opportunities to do other things. It has created opportunities to, be an action forcing event for certain things like signing or us pushing forward on something we wanted to do for a long time on labor, for example, or serving as a way to highlight what happened in the Indo-Pacific Economic Framework negotiations. Even though they're not directly linked, there's overlap with the countries. You had an opportunity because people were in town for things in San Francisco in November. So, I don't know that I would call it as a capping out. I don't think APEC has actually reached its full potential. And you consistently see, again, that innovation serving as an incubator for ideas. It's not mutually exclusive. All of these things are overlapping, just as our Indo-Pacific strategy as part of the US government is. So I think it's something you sometimes do have to look at a little bit like on case by case basis. There's other things happening. Do they reinforce each other in a positive way? They often do. They should not be in competition necessarily.
I don't know that ACUS, or I don't know that OIRA needs a lot more staff, but one or two people who would be dedicated to thinking about these issues full time would be a good thing. Plus, budget to travel would be a good thing. Certainly. I will attempt to, since these other two folks aren't able to speak to their issues on the transportation side, there was a huge effort to do this for autos in the TTIP days. If you're really interested in that, we can talk about that offline, but it didn't work out so well. One way I think about things is I think about it across kind of three different metrics. One, what is the number of companies, how big is the ecosystem of the industry? The second is what's the volume of the output, and the third is how complex it is. So what I mean by that is, if you think about it, there's really only two aircraft manufacturers in this conversation, Airbus, Boeing. So it's a much easier way to get your arms around. Yes, the supply chains around it are long, but there's one role up there. The volume is pretty low. You're not putting out tens of thousands of airplanes a month off the assembly lines. So the volume's pretty easy to get your arms around. Flying a plane is pretty complex on that scale. It's difficult, but if you can't at least get two of those three metrics to align, chances are mutual recognition arrangements is going to be tough to do because of the market surveillance aspects of this. You can agree that your regulations are virtually identical around the table, but how do you know that they're two adoptable in the market, which is a challenge in the EU based off the member state enforcement regime versus the the EU regime. But those are kind of three things there. And then look, USTR, they have transparency chapter, which was the early days of regulatory coherence. Then regulatory coherence or GRPs was there. There's always been tension between USTR and OIRA. Tim mentioned that, but too polite. The USTR fought the executive order tooth and nail. They wanted nothing to see this executive order but fail. Then when the executive order had its guidance written to implement, USTR fought for more than a year before that guidance finally came out. So there's a turf war inside the executive office of the president around this stuff that I think it's not been at its height today, but I think that's largely because there's not a lot going on in this administration, or for that matter, the previous administration on these issues. But I would imagine if this was to return as an agenda with some political importance, that turf war would reignite.
Thank you so much to our panelists. We're right on time. And thank you so much to our participants online and in this room. I will hand it over to Andy to close out the day.
Well, thank you, Elena, and everyone. I was going to ask about Brexit, so maybe we could talk about that afterwards. But thank you everyone for being here. Thank you for everyone in the cloud, and keep in touch with us on on this issue. We're going forward. We're looking forward to the report, and this is just the beginning of the relationship on this issue. Please.